Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Let's start with Judge Dad up in Michigan.
You weren't here. I didn't know you were here. Mr. Nasser said that this independent forensic exam couldn't take place because the doctor was out of the country and then in trial. So we're going to go ahead and adjourn it 6 weeks. It does not necessarily have to be on a Tuesday. But since I have a special prosecutor, but barring any conflict, I'm thinking October 28th at 9 o'clock. Is that good with you, Ms. Davidoff?
Your Honor, may I just quickly state that this has been adjourned now 3 times for competency. The independent was back when Judge Hessen was on the bench and we addressed this. I think at this point, if there are so many conflicts with this independent psychiatrist that Mr. Nasser looked for a different psychiatrist. This case is pending for months and months and months. I believe it began somewhere in February or March. In February, Your Honor, and the fact that we are in September and this has kept getting delayed and delayed and delayed, I think it is now appropriate to look for other psychiatric doctors, because at this point, you know, we're just kicking the case further and further, and it is not fair.
What is going on here? I'm seeing multiple adjournments. Can you enlighten? Well, there was a report done in June, right? We received a report in June.
Right.
That had to be from this.
From Wayne County.
Correct. So it hasn't been that much longer, but Mr. Nasser, her point is well taken. October, you're going to have to find somebody that is able to conduct this exam and complete the exam by October 28th with a report.
We'll have it done, Judge. And again, you know, Ms. Davidoff, I didn't get a chance to call her. I tried. No, Judge, we're not trying to delay anything. This is too important. And, you know, doctors have schedules, so does the court. We understand that. We'll certainly have it done. And, you know, we'll be prepared on October 28th, Judge.
All right. If somehow it isn't done by then, you're going to have to find somebody else, okay? October 28th at 9 o'clock.
Yes, Judge.
All right.
Thank you so much.
Thank
Have
you,
a
Your
good
Honor.
day, everybody. Thank you.
Thank you.
Judge.
Good morning. How are you?
I'm okay. 1 year anniversary on my son is Thursday.
Oh, geez, I'm sorry.
Yeah. Good? Yeah. Okay.
Kish Trollinger, 25E714-545.
Morning, Judge. Bill Cole, Chief 38434 on behalf of the defendant, Mr. Trollinger.
Mr. Trollinger,
Yes, sir.
I need you to start your video, sir.
I'm trying. It doesn't seem start video Alt V. Zoom is unable to detect a camera. Make sure your camera is powered on and connected to your computer. It is.
You have to start your video in the bottom left-hand corner of the device, sir.
Let me see. Alt V.
Mr. Clovis, when you're saying submit deviation request, are you talking about sobriety court?
That would be through Gary Branch.
Right.
First.
Are you talking about
Yes,
sobriety court here?
Yes. He has 2 priors that are very old, 97.
Yeah, I see that. What was the breath or blood here?
Was that? I believe one thing.
Was there an accident?
There was an accident, but I don't believe in injuries.
Okay.
And there's a question of whether the other lady pulled in front of me.
Mr. Trollinger, I need you to start your video, sir. Bottom left-hand corner of your device.
Your Honor, I'm trying. It will not detect the video camera.
All right, so you're going to have to appear in person going forward, okay? Defendant to
Yes,
appear
sir.
in person at all future court dates.
Apologize.
Yes, sir.
I recognize his voice.
Yeah, I get it, but
No, I understand.
so
It would be, if we could have the 30th, just because,
that's fine.
okay, thank you, and just, Judge.
Wait a minute, you're looking for the 30th for the exam, right?
The 30th, I thought, rather than the police come in, but if you want to have the exam that day, then I thought, I think.
Okay, here's what I'm gonna do. Mr. Trollinger, listen to me very carefully. You have the right to a probable cause conference within 14 days of the date of the arraignment. You have the right to a preliminary examination within 7 days thereafter. Your lawyer is asking for an adjournment. Assuming everybody can go, I'm prepared to schedule the PCC for September the 30th and the preliminary exam for the 7th. You available both days, Mr. Clovis?
Yes, sir.
But please send that to him because I'm not going to be too patient on
It'll
these.
be up this week, it's gonna go up.
Okay, so do you understand what I just said, Mr. Trollinger?
Yes, Your Honor.
Do you waive your right to have the probable cause conference within 14 days of the date of the arraignment and waive your right to have the preliminary exam within 7 days of the date of the probable cause conference?
Yes, Your Honor.
Anybody
That's what my
force you to
lawyer
do
said.
that?
No, sir.
All right, good enough. And you're on that SoberLink device, right?
Yes, sir.
All right, you have to still comply with all bond conditions. We'll see you. What time we do on September 30, Lisa?
15,
I'm sorry, you kind of cut out.
9:15,
And then the 7th
11 o'clock.
at 11 a.m. Okay? So hopefully he'll take them and we can,
That'd be great.
but just remember, I'm just telling you, they're not coming in with what's going to happen of a probation violation.
No, I know.
They're not coming in
Take
here
your
and,
discretion away.
well, you can't, they don't dictate to anybody else what's going to happen of a probation violation, and they're not going to do it with me. Have a good day. Thank you.
Okay, thank you, everybody. That will go.
Thanks.
Thank you, Your Honor.
Thank you very much. Markeline, like Carl Cargill, 25T 720788. Is Mr. Cargill here?
I thought she was in person.
Or her?
Yeah, but the attorney I had on Zoom, and I don't know what happened to him. I lost him.
You have to start in with me, Lisa.
She called me this morning and said she was running a little bit late. The defendant, she had to drop her child off at school.
That's well.
Well, would you yell out there and then, quietly kind of, Markeline Cargill, if she's here, she has to come into the courtroom, please.
I'll do it right now.
Thank you. Felony. I mean, I don't know where she would have dropped her child off, but she was supposed to be here at 8:30. School's usually starting by 8:30.
Sir, can I get
Yeah.
your name in the jail?
Sir, what is your name? You have to unmute and tell us your name in the jail.
Kenneth Van Leuven.
Say that again?
I got it, Van Leuven.
Okay.
Just give me a minute. I'll get you with your attorney, okay?
Okay.
Have anything else down there?
You got a couple of them.
So you wanted to do this one?
This is not up to date.
It is not.
Okay, have her,
For violation?
yes.
I'll call her then.
For the prosecutor.
Yes. Thank you. These are waivers.
So they just brought this time.
I hope Ross Young family heard what happened. I adjourned that until October the 28th. October 28th. And what is Liberty Turner PC, Lisa? Do you know what they're here on?
She's here to help Mohammed.
I see.
I'll message the Ross Young family.
Okay, thanks. People against Castro. Jorge Orlando Ayer Castro, 25M588576. So I'd need Trooper Byer and Mr. Castro. All right.
Do you have a Samsung that I can't identify?
Samsung phone. Where is it? I need you to tell us your name, Samsung. SM9. Start your video, please, and tell us your name. What's your name, sir? You have to unmute.
U-U-R-A, Yuri.
Tell me your name again.
A U-U-U-R-E.
Are you Jorge Castro? Are you Jorge Castro?
Yes, yes.
All right. Okay. You got it. If you ever get another ticket, you have to log in with your real name, okay? I'll just make a note. The officer failed to appear. Case dismissed. This was scheduled for 9:15. I give him 15 minutes. It's 9:33. You are all set. Case dismissed. Good luck. People against Megan Ann McGuire. So you win, Mr. Castro. You're a winner. Good luck.
Okay.
Megan Ann McGuire, 25M588775. Ms. McGuire, your name?
My name is
McGuire.
Ma'am? Do you see?
Can you hear me?
I can. Just give me 1 second here. I'm just double checking to make sure the officer isn't here. It appears he's not. This is the same trooper on the other one. Case dismissed. The officer failed to appear. You're all set. You win. Just slow down a little bit. Okay, ma'am?
Will do. Thank you very much.
Have a good day. Thanks.
You too. Bye.
Mr. Van Leuven, join the breakout room.
People against Aaron Michael Fleazar, 25T721893. Your name?
How do I do that? Huh.
Your name? Raise your right hand, please. You solemnly swear affirm on penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got. So just for the record, on September 12th, Judge Mullins arraigned the defendant. She set a $5,000 cashier surety with a but did she has C/S/10, which I'm assuming means 10% with GPS tether, no alcohol, no firearms, no GPS tether shall be acquired through house arrest within 24 hours of posting. Is defendant posted? Do we know?
I assumed he did. Heather had contacted me to send a referral. I didn't see anything on the register.
Lisa, do you know if he posted?
Judge, Sergeant Driscoll, Trent Police. I do have a little insight to that case.
Okay.
He did post. He reclaimed his vehicle. He did not go to house arrest. I contacted him yesterday. They do not have anybody registered under his name. The other insight that I have is we have access to flock cameras. He was last seen, his vehicle was last seen near Chattanooga, Tennessee, heading southbound.
Oh, nice.
Yes.
You don't think he's fleeing, do you?
Maybe a little bit, Judge.
Probably just going down to sweet great state of Tennessee for a while. Raise your right hand. You solemnly swear affirm under penalties of perjury. The testimony you'll give in these proceedings will be the whole true self you got. All right, go ahead and give me a little bit of testimony.
I just received an email from House Arrest Services yesterday, September 15th at 5:01 p.m. that he still had not obtained the GPS tether. And then the defendant didn't provide the court any phone number. He claimed he didn't have a phone number. They have a camera, a camera. So it is
I mean, that's impressive.
like unique.
Oh,
I'm gonna find by preponderance of evidence that the defendant violated the bond conditions by failing to acquire PS tether, release revoked, bond forfeited, $50,000 cash or surety, bench warrant to issue. Detective Driscoll, can you hear me?
I can, Judge.
How did you know this?
I was actually the officer in charge of that matter. When Judge Mullins gave the sentencing and she wanted it on by Saturday, I just called to confirm yesterday with court administration, Amy Zawacki, that he did not appear. So I did a little investigation with it.
And how'd you figure out he's in Chattanooga?
We have Flock. It's a license plate reading access that we have.
Wow, amazing. All right, well, I'm revoking the release, forfeiting the bond, bench warrant to issue, 50,000 cash or surety. So that bond will be forfeited. And I find by a preponderance of the evidence, there's been a violation of the bond conditions and the defendant failed to acquire a GPS tether. And also I need not add, but he left the state without consent. So that's what I'm doing. Have a good day. Thank you very much. All right.
Mr. Van Leuven, can you get a deputy to help you get in the breakout room? Mr. Tucker, do you need to speak to your client?
Miss-
Mr. Rucker, I'm sorry.
No, I don't.
Okay.
We spoke.
Where do I have, who's Mark Heelan's Cargill's lawyer again?
Mr. Williams, I have to call him. I lost him on Zoom.
Yeah, get him back in here, please, and we'll go from there.
County, can you see it on the screen to move?
Can you send it again? He touched the screen and canceled it. Can you send it one more time, please?
Yep, sure.
This is my judge.
Stephen James Bolent, 25I-718-730. Where is Mr. Carmen? I need your lawyer.
It's 29.
Oh.
Go ahead. Why don't you have a seat, sir? Okay, so the Ross Young family, I don't know what to tell you. I got all these names and people on here that I think I've already called their case. And who else? Samsung S9, was that Mr. Castro, I believe? Think, so he can be removed from the screen. People against Stephen James Valent, 25I-718-730.
Good morning, Your Honor. Michael Lee Crockett, 273, people on behalf of the defendant.
Your name, sir?
My name is Stephen James Ballin.
So he says here, this is going to be a plea to OWI with the, I'm sorry, he's going to plead to super drunk count 2, I believe. Let me just double check that. He's going to plead to super drunk and the OWI count. That's count 1, actually. In fact, I'm going to move these. Give me this. Jeez. All right, he's going to plead to count 1 super drunk with the understanding that count 2 will be dismissed. There's recommended 24 months probation. This is not a sentence agreement, correct? It's not.
We know better.
And then alcohol screening and assessment, and then referral for sobriety court.
Yes, sir.
What was his blood or breath test again?
It was I think it was a 0.5.
Point what again?
0.5.
50 or something? Yeah, I kind of remember this. All right, so do you understand what's going on here?
Yes, Your Honor.
If you plead guilty here to super drunk, I'm going to take that plea. I'm going to dismiss the operating while intoxicated. I'm going to refer you for a screening and assessment, and we're going to get you on bond conditions for sobriety court. We're going to determine whether or not we're going to accept you. If you show an interest and you show up and you do what you're supposed to do, we're going to accept you. But I want you to understand by pleading guilty here that you could get up to 6 months in jail, minimum fines 200, max 700. Since your other prior was in 2014, right? You had 1 prior.
Correct, Your Honor.
I can't immobilize your vehicle and your license will not be revoked, but it will be suspended. Do you understand that?
Yes, Your Honor.
And did you sign an advice of rights form?
Sorry.
Take your time, read the advice of rights. John, no, right here on this plea form. Hand him that tab.
Sorry, Your Honor.
That's all right.
I'm ready on Van Leuven.
Hang on, Mr. Margolis. I'll get to you as soon as I can.
Of course.
All right, sir. Did you sign and read and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and we will not have a trial of any kind. Do you understand that?
Yes, Your Honor.
And you understand, have you been educated about what sobriety court entails?
Yes, Your Honor. I have a packet.
Did you read it?
Yes, I did.
Did you understand it?
Yes, I did.
All right, to the charge of operating while intoxicated, operating with a high BAC, how do you plead?
Guilty.
On July 17 to 25, were you operating a motor vehicle on Meridian and near Macomb in Grosio Township?
Yes, I was.
Did you drink alcohol before that? And if so, what did you drink and how much?
Yes, I did. I drank 2 beers, 2 8% beers, and I drank the night before. I drank liquor.
You had 2 8% beers at what time?
At around 9 o'clock, 9:30.
In the morning?
Yes, sir. Yes,
And
sir.
how much did you drink the day before?
I think I had maybe 4 or 5. I'm gonna say 5.
5 what?
Vodka sodas.
Okay. And were you hand pouring these at home?
Yes, Your Honor.
Do you know how many shots roughly you were putting in each drink?
I do not know, Your Honor.
You said the breathalyzer or blood was 0.50?
So, Your Honor.
What else did you drink?
That is all I remember, Your Honor.
Were you pouring listen to me. You can't get there with 4 shots the night before
No.
and 8% alcohol beers in the morning. You cannot come close to 0.5.
Yep.
It's not even a contest. I mean, it's not even. So I need you to search your mind and tell me what you drank.
I was drinking, it was called Pink Whitney. That's vodka. And then I drank vodka, a bottle of vodka all the time.
So you had 4 drinks plus a bottle of vodka?
Yes.
Was that a 5th of vodka?
Yes, Your Honor.
The night before?
Yes, Your Honor.
And what time did you go to sleep?
I do not recall, Your Honor. Maybe around midnight.
Okay, and then you woke up in the morning and you had 2 beers.
Yep.
8 ounce alcohol. I'm sorry, 8% alcohol, 12 ounce, right?
Yes, Your Honor.
And you were pulled over at about what time?
11 o'clock, 11:30
In the morning.
in the morning.
Why were you pulled over?
I hit a rock. I turned and hit a rock coming out of my condo complex.
Okay, was the rock off the roadway, obviously?
Yes, Your Honor.
Was it in your condo complex?
Right next door, Your Honor. I live right next to the gas station.
Okay, and so you're coming out and you strike a rock that's on the condo complex's property.
Yep.
Correct? How far is that rock located off the road?
It is located
Just tell me how far off the road.
maybe 10 feet.
All right. And did you call the police or did somebody else?
Somebody else called the police.
Police came to the scene, you went through field sobrieties. Was that a breath test or blood draw? Mr. Kerman.
Blood. They did a blood draw.
And do you stipulate that that was an accurate reading of 0.50?
They stipulated.
Are you on probation or parole right now?
No, I'm not.
Has anybody forced you to plead guilty?
No, Your
So you know you're gonna, and I don't mean to be harsh about this, you don't get in this program, you're gonna die. Have any of the SoberLink bowls been positive?
Right now, he's also been doing AA 5 times a week.
Good. Good. All right, good enough. I'm gonna accept your plea. I find it to be an accurate plea made voluntarily and understandingly. So the plea is accepted to super drunk violation, that is operating while intoxicated with a high BAC. The OWI is dismissed. I'm referring you for a screening and assessment. We're gonna set this out. We have a graduation today. Do you work?
Yes, Your Honor.
Where?
At the Lincoln Center in Wyandotte.
What do you do there?
I'm a paraprofessional.
We have a graduation at 3. I'm not gonna make you come because it's short notice today. But if you can make it, I'd love to have you here. This is the highest blood or breath result I've ever seen in my career as a lawyer or judge, and I'm not trying to make you feel bad, but we got to take some action here. So, Lisa, why don't we go out to about October 28th for sentencing, okay?
Okay.
And we can do that at 8:30 in the morning, Mr. Kerman. And in the meantime, you take them over. The bond is continued, all other aspects, and you're going to comply with any bond conditions that probation sets for you. You're going to immediately start testing, and you're going to have to pay for that. And then once we get you into the program, our grants will cover your chemical tests, your SoberLink. So weather the storm.
No, I'm sorry. What was the date for sentence?
October 28th. That should be a Tuesday, right?
Yep.
Okay. You good that day?
Yeah.
All right. Good enough. Thank you.
Friends, I don't think that's a super drunk. I think that's a super duper schmooper drunk. That's crazy. But some people build up a tolerance. What can I say? He's gone pro. He's career. And hopefully he gets his stuff together because eventually it'll kill him. Either, through an accident or through his liver being totally destroyed or whatever. And hopefully he doesn't take somebody with him. But good morning. Happy Tuesday. Welcome to the Courtroom Files Live once again. Michael, congratulations on, what was it, 4 months now as a channel member? Yes, 4 months, and thank you for gifting the membership. Very much appreciated as always. Let's go to Florida. Say good morning to Wade Mercer.
Here on your behalf, you're here for a failure to appear in a case 24-598 CT. It looks like a case, as best I can tell, you were sentenced to 10 days in jail, but you were given a chance to come back to court if you couldn't get a fine paid. And then when you didn't show up for court, the warrant was issued. So, Ms. Graham, listen to Mr. McDaniel. We're going to see where we stand in your case, ma'am.
Yes, sir.
Your Honor, we'd ask the court to amend the sentence 24-598 CT for a $400 purge. She's sentenced to 10 days in jail. She has 4 days credit today. Yeah, we just asked the court to amend it, let her go ahead and purge out of the jail.
Mr. Mitchell, any objection to that?
No objection.
All right, Ms. Graham, I'm going to add a purge to your sentence right now. It's just a straight 10 days. You have very little criminal history. And the goal wasn't for you to ever go to jail. The goal was for you to pay the fine or come back to court and ask for an extension. And when you did neither, that's when the warrant was issued. So, ma'am, I'm going to add this purge to your sentence. Purge is $400. So let me tell your daughter what that means. So what that means, ma'am, is she's already got a 10-day jail sentence that was imposed months ago, but she didn't have to do it as long as she paid the fine. When she didn't pay the fine, that's when the 10-day jail sentence kicked in. I've now added a purge. The purge amount is the same amount she was supposed to pay months ago, $400. When that purge amount is paid, she'll be released. So if it's paid today, she'll be released. Now, here's what you got to understand. The purge has to be paid at the clerk's office while they're open. They're open till 4:30. So if you go pay it, what they're going to do is they're either going to give you a receipt or they're going to send an email to the jail that it's been paid and she'll be released immediately and it's over with. Do you have any questions? Ms. Graham, do you have any questions?
No, sir. Thank you.
If you wait just a second, we're going to give you this paperwork, ma'am, so you can take it downstairs and pay it. Your daughter's going to try to get that taken care of this morning, Ms. Graham, okay?
Yes, sir. Thank you so much.
Yes, ma'am. Kristen Foster is next on the list. Foster, good morning, Mr. Foster. You're here in case, actually, you don't have a case number yet. It's a brand new assault charge from yesterday. I've read the complaint. There is probable cause. You also have a pending violation of conditional release on the case you're on pretrial intervention for, which is 25-390 MM. And Mr. Mitchell advised me that Mr. Foster's your mother is in the courtroom, ma'am. Did you have something you wanted to say? You can come on up so he can hear you. I'm talking this microphone right here, ma'am.
Yeah, if you want to. I was going to put that on the record, what she had been in contact with the alleged victim in this case, but if you allow Ms. Foster, she can.
Sure.
Is that okay? Okay. I have a text message from Lainey, which was the alleged victim. Her and Christian tried to contact her, yesterday and me, which there was no contact. And it says if Christian is able to get with you on the phone, let him know I added money to his account so he should be able to call me. So with that lets me know, obviously she's not afraid of him. She's going to put money on the account.
Okay.
Also yesterday, Lainey was very upset. I went outside after Christian was gone and she was trying to do some damage to his truck. She did not. She was very upset. I stopped her and calmed her down. So there is a little bit of that, but I just wanted to let the court know that it could have went. I could have called the police, let her show out, but I did not want any of that. Okay. She's a good person, just a lot of emotions.
Yeah, there's something going on with Christian. He never been in trouble with his life.
No, sir.
And in the last 2 months, he's been arrested twice.
Yes.
So I'm going to hold him with no bond because there was a condition, no violent contact. And the complaint alleges violent contact, and he admits to hitting the windshield and cracking the windshield in the complaint. So he's not going anywhere. He's going to be with us for a while. We'll figure out what's going on in his life to just all of a sudden he's getting arrested twice in a matter of weeks. He hadn't been arrested in his whole life. So that's where things stand today. But thank you for coming today and giving me that additional information.
Do we know how long, Judge Murphy?
I do not know. Mr. McDaniel is going to give us a court date in just a second.
Okay. Thank you.
So, Mr. Foster, I'm going to sign the order. Actually, I already signed the order on your violation of conditional release. So issue number one is I got to get that warrant served. I don't want you getting picked up on this warrant 2 or 3 weeks from now. I'm going to ask Sergeant Applewhite to serve this warrant that was signed this morning for getting arrested while you're on conditional release and pretrial intervention. Sergeant Applewhite.
Thank you, Your Honor. Good morning. This is Sergeant Gary Applewhite with Jackson County Sheriff's Office.
Are you Christian Foster?
Yes.
Okay, is your date of birth September 14th, 2002?
Yes, sir.
Okay. In my hand, Mr. Foster, I have a copy of the show cause for your violation of conditional release. Please consider yourself served on this show cause, and a copy of this will be provided to you before the end of the business day today.
Thank you, Sergeant. So, Mr. Foster, you've got no bond in that case. I'm about to set you a bond in the new case. Don't try to post it, because even if you post it in one case, you wouldn't get out because you've got no bond in the other case. The bond in the new assault case is $5,000 cash or surety with a condition of no contact with the alleged victim. And that means no contact at all. Whatever's going on between you and she, it's stopping now, and there's no contact. So, Corporal, I'm going to ask that you monitor his jail conversations. And if he does have contact with her, let me know that. So I can take appropriate action. So no contact with her. I don't care what she's asking for, what she wants. This is got to stop. So no contact with her. I'll give you a chance to ask a question in just a minute. No contact with her at all. And as far as his next court date, Mr. McDaniel, what court date would you like Mr. Foster to be set for?
October 8th. Raymond.
October 8th. Mr. Mitchell, anything from the state?
Just that I wanted to put out, our office will be in contact with the alleged victim in this case. And if we may be able to reach an agreement, we may try to resolve both of the cases with that agreement, if that's okay with the court.
Sure. Y'all can bring me any tentative agreement that y'all have reached. I'll be glad to look at it. Mr. Foster, do you have any questions now?
Yes. How do I go about a custody agreement to see my son?
You need to see an attorney about that.
All right. That's the only issue we have.
All right. Wish you the best, sir.
Yes,
So
sir.
now October 8th, unless if Mr. McDaniel, sometimes he'll bring somebody up earlier if they get something worked out. So you may want to make sure the public defender's office has your phone number. But you know, we've got to do something to figure this out. Whatever's going on in Christian's life, we've got to fix it. Hey, he's on conditional release, right? Yeah, he's on conditional release. So, Corporal,
Yes, Your Honor.
let's give him a urinalysis after first appearance. I'd like to know the results of that. Since he's on conditional release, I can do that. Okay.
Yes, sir.
Thank you. Then we have Melanie Pollock. Miss Pollock, good morning. Miss Pollock, your mother is in the courtroom, ma'am. You're here for first appearance for 1, 2, 3 new charges of possession of controlled substance. Miss Pollock, there is probable cause for those charges, and it appears to me you're already out on bond in 25-116 CF. Let me see if the attorneys have any additional information, and then we'll see where we go. Mr. McDaniel?
No, Your Honor.
Mr. Mitchell?
I'm sorry, Your Honor.
Ms. Foster, finish your conversation later. We got more cases to hear. So she's already out on bond in 25-116.
Yes,
What's the state's position?
Your Honor, given that information, and if I recall correctly, I think 25-116 was also a drug charge. Let me double check.
I think it may have been felony petty theft.
That's right. It was felony petty theft. State would ask that our bond be revoked at this time, and I'll prepare a proposed order.
Thank you. Ms. Pollock, I'm going to set your bond in the new cases, which you're entitled to a bond on at $10,000 each. You've got 3 of those. So your bond for those cases is $30,000. Do not try to post it, because I'm revoking your bond in 25-116 CF. So, ma'am, talking to your mother now, the one she's already out on bond on, she's got arrested for new felony charges, so her bond is revoked. So you've got no bond in one case. You've got a $30,000 bond in the other case. The $30,000 bond case does have a condition of random urinalysis. So if at any point you're on bond, if Judge Garcia, lets you out at some point, you've got a condition of random urinalysis. You have a condition of no contact with the alleged victim. Actually, there's no alleged victim in this case. It's possession of paraphernalia. We do need to give you a notice for your court date. I'm trying to look at that notice.
Don, does she already have a court date for 25-116?
Yes. It's a pretrial date though, so it's October 21st. So she needs to be on the October 7th arraignment document.
October 7th will be your court date, and the 3 new felony cases will be your arraignment date or your status conference date, depending on whether an information has been filed. Ms. Pollock, do you have any questions?
All that I was saying in this case right here, when they arrested me, they threw all that away. They let that go, and all of a sudden, then I had a warrant for these 3 new charges. I mean,
yeah, what it looked like, according to the complaint, it looked like they were waiting on some lab results because they weren't sure of the identity of some of the substances. That's what the complaint says, Ms. Pollock. That they were sure about the methamphetamine. I cannot have no idea why they didn't arrest you for that charge then, but I guess they did some kind of further testing on the other substances, and once they got those test results back, that's when they asked for the warrant. That's what the complaint says.
They let me go because what they found, everything they found was on the ground. And it was a guy that was mowing the yard, and I was at somebody else.
So,
okay, it don't matter.
Yeah, that's not what they're saying, Ms. Pollock. They're saying they saw it fall out of your pocket. You have any questions, though?
No.
All right, have a good day, ma'am. Ma'am, in the courtroom, do you have any questions? Thank you for coming, ma'am. We have one more person here that has friends or family, and that's the last one on the list, Darren Frazier. Let's go to Mr. Frazier next. Mr. Frazier, good morning. Mr. Frazier, your mother is back over here today supporting you. Mr. Frazier, you're being brought back up. You had a violation of PTI from last, I believe Friday is when I saw you. Mr. Frazier, I'm going to appoint the public defender's office to represent you in this case. It's 25-173 Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Mr. Frazier. He's going to plead of no contest to charge of petty theft. Understanding he'll be sentenced to 6 months of probation, no early termination, retail theft class, $370 fine, restitution previously owed in the PTI case, withhold adjudication, and he will be signing his plea waiver form waiver about the jury trial and call witnesses.
Mr. Frazier, listen to Mr. Goodson with the probation office because I think you've already paid some of that fine and perhaps all of the restitution. So let's make sure we got the numbers right.
Thank you, Judge. So Mr. Frazier, John, was originally put on PTI and he did not have a public defender. So his original fine was $270. Since he's has a public defender today, the fine would be $370, but he paid $65 towards the fine. So we actually going to have a $305 fine balance, and his $333.76 restitution on that case, and the other $5 that the state has agreed to dismiss, that was paid in full. So he just has a $305 court cost, and he already completed retail theft school. He did it after the warrant was issued. His mother bought in the certificate Friday.
Thank you, Mr. Goodson. Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor, and those other cases were review cases that our office has. And since this is a probation plea that he's accepting, I will close out those remaining review cases.
What's your position on withhold adjudication?
I have no objection to withhold an adjudication.
Mr. Frazier, could you hear that agreement, sir?
Yes, sir.
Mr. Frazier, any questions about that agreement?
No, sir.
And is that the plea you would like to enter to resolve these cases?
Yes, sir.
All right, so what I'm going to do is I'm going to show a plea of no contest. I'm going to accept that, find it's freely and voluntarily entered only in 25-173 Those other cases will be dismissed. Those cases are put on the record previously. Those were review cases. In 25-173 I'm going to withhold adjudication, be up, place you on probation for 6 months. No early termination in this case because you've already had a pretrial intervention opportunity. You've got everything paid in the restitution. You've got $305 left in court costs and fines, and you've already done the retail theft program. So all you've got to do, Mr. Frazier, is report in once a month like you're supposed to, stay out of trouble, get your court costs and fines paid, and get this thing behind you and move on with your life. So let me tell your mother what's going to happen next. So, ma'am, what's going to happen is they're going to let him get dressed in his regular clothes. They're going to bring him to the courthouse because that's where the probation office is at. When he gets here, he'll meet with the probation officer. That'll take 10 minutes. They'll give him a chance to ask any questions he has. They'll give him a copy of all the probation rules in writing, and he'll be free to go. I'm assuming he's still living in the Jacksonville area, so they'll talk to him again about mail-in reporting or email reporting. Make sure he doesn't, miss that. But usually it's a 30 to 45-minute process to get him here once we get through with court. So he'll be downstairs in 30 or 45 minutes. Do you have any questions? Mr. Frazier, do you have any questions?
What did he say?
Any questions?
Oh, no, sir.
All right, Mr. Frazier, wish you the best. Thank you, ma'am, for coming back again. Yes, ma'am. That's it for friends or family, Mr. McDaniel, so we can go back to where we left off on our list, and that would be, let me see Ms. Paul first. Kristen Paul. Ms. Paul, good morning. Ms. Paul, you're here for a violation of probation charge, ma'am. You're, actually, for this part, I can see Mr. Peak also. Let me see, John Peak and Kristen Paul. So Ms. Paul and Mr. Peak, you're each charged with violation of probation. Mr. Peak, good morning. You're each charged of violation of probation or community control, and in each case, the circuit judge has signed a no bond warrant. So first, I want to go ahead and get you both arraigned and give you a court date and see if you have any questions. Do we have a third case there, Mr. McDaniel?
Mr. Williams.
Mr. Williams is the same situation, isn't he? But he's got a new charge too. So Mr. Williams, listen to this part also because it applies to you. All of you have no bond warrants in probation cases. In all three of your cases, I want to get you arraigned and get you a lawyer appointed if you're asking for one. And then we're going to talk to you about your court date and see if you have any questions. Ms. Paul, do you want an attorney appointed to represent you? I think it's muted, Mr. McDaniel, perhaps.
Yes, sir.
Perfect. Mr. Peak, would you like to have an attorney appointed to represent you?
Yes, sir.
All right. And Mr. Williams, same question.
Yes, sir.
So I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, and then we'll see if you have any questions.
Your Honor, we're going to interplead not guilty. Yes, to set this on October 9th, pretrial docket, and I advise them, Mr. Green, to come by and speak to them prior to that hearing.
October 9th. Mr. Mitchell, anything from the state?
No, Your Honor.
Ms. Paul, do you have any questions, ma'am?
No, sir.
All right. So Mr. Green will see you before your court date, ma'am. Have a good day. Mr. Peak, yours is a little bit confusing. So Corporal, I don't know that I've ever seen this. Corporal, the paperwork sent from Calhoun County says hold him, but then it says ROR. So those are contradictory. So I'm going to ask the jail to notify Calhoun County because Mr. Peak needs to know whether or not Calhoun County has a detainer on him or not. When I looked at the file that showed him be given the first appearance ROR in Calhoun County. So I'm not sure how they could have it both ways. Maybe something's wrong with his paperwork. So Mr. Peak, I'm not real clear if Calhoun County wants you back in the form of, you've got to go back to court. That's clear. What's not clear is, do they want you back in custody, or when you finish your matter here, your probation matter, are you going to be released to go back there on your own at a future court date? I'm going to ask the jail to try to clarify that for you because I frankly can't tell. Mr. Peak, do you have any questions?
Yes, sir. I kind of clear that up for you. What it is I got a misdemeanor there, and they want to give me time served on it. However, I wouldn't take the plea because, taking that plea would be, my probation.
Could violate your probation, right?
Yes, sir. So they did say, what I'm saying, they're anticipating that I probably take a plea for my probation and just run it, just say, well, I'll take the plea there and let it go. So is your understanding that you're supposed to go back? You're supposed to stay in custody once you resolve your charge here and go back to their jail? Or is your understanding you're supposed to be released and then get a court date? I'm supposed to go back to the jail, but hopefully it ain't gonna come to that because that's supposed to get thrown out. So it's supposed to be a hold on because I asked them specifically, was there a hold on? And they say, yeah.
Yeah, it says hold in big bold letters, but then it says ROR, and ROR is what the judge at first appearance did. So we'll let y'all figure it out, and they may resolve it in felony court. They may dismiss it if you admit to the VOP, and then there won't be a hold for sure if it's dismissed. But we'll let y'all figure it out, okay?
Thank you, sir. You have a blessed day.
You too. Wish you the best, Mr. Peak. And then we have Mr. Williams, and Mr. Williams, your case is slightly different. So first, I've already told you about the VOP, but you also have a pending charge of driving under the influence that you were first appeared on last week. Mr. Williams, in that driving under the influence, I think the public defender's office has already been appointed. So listen to Mr. McDaniel to see where we stand in the DUI case. Mr. McDaniel?
Yeah, it's set for an arraignment docket. I've never got an offer on the case, I don't think. Did I get an offer?
Today
It was 60 days.
Today you got one because of the VOP warrant. The tentative offer was 60 days. Mr. Mitchell, stay agreeable with that?
That's what I saw in the text. 60 days jail. Yeah. Yes. Yes. He's the one that they originally charged us, just the refusal, and then we had, I think under the new statute, you can actually get them for that.
So when he was first, I wasn't the first appearance judge. When he was first appeared, the complaint was only for a refusal
Yes,
and not for a DUI.
Yeah,
Really?
it was an error on behalf of the officer. They literally were texting me during that saying we're getting another complaint in showing.
So did he get first appeared on the DUI the next day?
Yes, he did.
Okay.
Your Honor, he's going to enter a plea of no contest to the charges as listed. The understanding he'll be sentenced to 60 days in county jail. I'm gonna have to figure out how much jail credit he's got. Be $1,078 in fines. He's gonna waive his right to a jury trial and call witnesses.
Can't.
Hang on, sorry. And how much jail credit y'all have? Y'all got jail credit?
Maybe 9. Sunday night, Monday, Tuesday, Wednesday, Thursday, Friday, Saturday.
Call witnesses.
Monday, Tuesday. I've got 10.
What day was he first appeared on?
He was first appeared last Monday, and then he was brought back the next day with Judge Green.
7, 8.
I got 10, John.
But 10 can't be right because today doesn't go to that credit.
Oh, okay. Then I think it's 9.
He's got 9. You okay with 9, Mr. McDaniel?
Yeah.
I'm fine with 9. I counted 8, but that's fine. 9 would be good.
Mr. Williams, did you hear that agreement, sir?
Yes, sir.
And just to
I got
clarify, let me clarify one thing, and I'll be glad to see if you got a question. Mr. McDaniel, he's pleaded the DUI as well as the refusal, correct?
Correct.
Okay, you have a question, Mr. Williams?
Is there any way we can waive those fines, considering that with the DUI, I don't have access to a job at the moment?
No, can't waive them. What you can do is you can do some community service for them. Okay, but I can't. I'm not going to waive them just because someone's unemployed. But certainly glad to let you do community service for them. Okay.
What does this mean for my probation since I've already paid it off? Does it just extend or continue while I pay these fines, or is it unsuccessful?
This has nothing to do with your probation. Mr. McDaniel asked that he always asks that a condition be put on your plea that this will not be used against you, that this plea will not be used against you in VOP court. In other words, what happens down there is between you and the state and ultimately the judge in violation of probation court. They may use this to violate your probation. They wouldn't use what happened today, but they could use the incident by calling witnesses to show that, try to convince the judge that you violated your probation by committing the act of DUI and or the other charge. But they can't use your plea today, what happened today, to hurt you. So I have no idea what will happen. There's a lot of things the judge looks at: your criminal history, how long you've been on probation, what was the original charge you're on probation for. All those are factors plus others that she will use to decide an appropriate sentence in felony court. Any other questions?
No, sir.
Is this a plea you want to enter to resolve the misdemeanor charges?
Yes, sir.
And Mr. Mitchell, it's agreeable with the state?
Yes, Your Honor.
Mr. Williams, I'm going to accept your plea of no contest to one charge of refusing to submit to breathalyzer, one charge of driving under the influence in case 25-474 CT, adjudicate you guilty of both offenses, sentence you to 60 days in jail on each case concurrent. That means running at the same time. 9 days credit on both cases, $1,078 court costs and fines in the DUI, no court costs and fines in the refusal. And there's a condition that this plea will not be used against you in a violation of probation hearing. That does not prevent the state from using the incident, only the plea from what happened today in court. Mr. Williams, when you finish the 60-day sentence, you'll be through with the misdemeanor case. You may or may not get some gain time on that case. Talk to the jail if you want to try to be a trustee. And then you come to the court date Mr. McDaniel's already told you about, or I told you about, on the VOP charge. Any questions at all?
No, sir.
All right, sir. Wish you the best. We have John Terrius Smith next. Mr. Smith, good morning. Mr. Smith, you're here because you've been accused of one charge of burglary of an occupied conveyance, which is a second-degree felony, and one count of criminal mischief, a misdemeanor. There is probable cause in the charge, and we're just going to try to get you a bond set. But I think you've already got some sentence you're serving a sentence on, right? So,
yes, sir.
But you're still entitled to a bond. It may be important at some point, even though it doesn't matter right now because you couldn't get out anyway until you finish that other sentence. But let me see if the attorneys have any additional information they want to make sure I'm aware of before I set this bond. Mr. McDaniel.
No, Your Honor.
Mr. Mitchell.
Judge, I know that The incident that he's being first appeared for today occurred on September 8th of this year. I don't know if that affects because he was still on probation at the time, but he's already pled to that. I don't know how that works. I just wanted to bring that to your attention.
To answer, just in case that raises a question in your mind, Mr. Smith, you've already resolved that VOP. You can't be punished again for it. It's over with. You can't, once you're no longer on probation, you can't be violated again. So even if it happened while you're on probation, you've already been sentenced for a VOP. So Mr. Smith, I'm going to set your bond at $10,000 on the second degree felony burglary, $5,000 on the criminal mischief. That's $15,000 cash or surety with a condition, no contact with alleged victim. Also, I'm going to ask the jail to give you a notice for your court date. That will be October 7th at 8:30. That's when you'll be in court on the felony charges. Mr. Smith, do you have any questions?
Can I ask you who was the alleged victim in this case?
Sure. Sure you can. Give me a second to look it up, Mr. Smith.
I might be able to get it. Hold on just a second.
It's 25424.
It is Patrick Allen Pender.
That's the alleged victim.
That's the
Was there
alleged
more than
victim.
one person?
Let me see.
Who is it?
There were a lot of people on scene.
But who was in the car? That's the person.
Mr. Pender. He and Miss Spencer, Miss Spencer also.
Yeah, so no contact with Keziah Spencer and no contact with Patrick Pender. Any other questions, Mr. Smith?
What's the address? So maybe, because he don't know who these people are, so.
No, I mean,
Okay, let me, don't comment on this. Don't comment on this, but I'm gonna kind of summarize the complaint. I want you to understand what you're accused of. The allegation is that on September 8th, which would have been 8 days ago, 5100 Highway 231, there was allegation involving criminal mischief. The allegation is that Mr. Pender said he picked up Miss Spencer from work, took her to 5100 Highway 231 to her home. While she was retrieving her clothes, her live-in boyfriend, John Terry Smith, was observed approaching the residence. It should be noted Mr. Smith's mother resides nearby. And they had y'all supposedly had ongoing issues. She says she tried to end your relationship earlier that day. She moved along pretty quickly with that. Mr. Pender reported as he and Miss Spencer were seated inside his vehicle preparing to leave. Miss Smith struck the vehicle on the driver's side frame near the window with a wooden object resembling a table leg. And when he confronted him about the damage, when Mr. Pender says when he confronted you about the damage, that you allegedly opened the rear side door of his vehicle, reached inside and took her purse. So that's what you're accused of. Don't comment on that, but that's the incident they're claiming. Any other questions?
No.
All right. Wish you the best, sir. After Mr. Smith, we have Michael Eubanks. Mr. Eubanks, good morning. Mr. Eubanks, you're here for first appearance accused of one count of dealing in stolen property and one count of petty theft. The dealing of stolen property is a second-degree felony. The petty theft is a misdemeanor. Mr. Eubanks, the criminal history I've been provided shows no prior criminal history. Mr. Eubanks, is that accurate?
Yes, sir.
Have you ever been charged with a crime anywhere?
No, sir.
How old are you?
20.
You have a job?
I had a job
When was the last time you worked, Mr. Eubanks?
before I got arrested. Before I
Yeah, but
turned
when
myself
specifically? Did you work yesterday? Did you work the day before or when?
like 3 weeks ago.
Where was that at?
Hardy's.
Okay. And you have a twin brother that we saw yesterday, correct?
Yes, sir.
Okay. Let me see if the attorneys have any additional information and then we'll see where we go. Mr. McDaniel, anything?
Go ahead. No, we just asked for conditional release.
Mr. Mitchell?
I have no objection to that.
Yeah, I normally don't give a conditional release on a second degree felony, but I rarely see second degree felonies with no prior history. So Mr. Eubanks, I'm gonna let you pick between a bond and a conditional release. If you like to post the bond, if he chooses the bond, Mr. McDaniel, I prefer to set a cash bond if the state and defense are okay with it. Mr. McDaniel, if he chooses the bond, are you okay with the cash bond?
Yes, Your Honor.
Mr. Mitchell?
No objection.
So if you choose a cash bond, it's going to be $500 on the dealing of stolen property. Actually, it's not going to be that amount because of the value of the item as well as the lack of prior history. It's going to be $250 cash and $100 cash on the petty theft. So if you choose a cash bond, it's $350. If you choose a conditional release, I am going to offer you a conditional release. Either way, you will have a condition of no contact with any Walmart while the case is pending. Mr. Eubanks, do you understand your choice between the bond and the conditional release?
Yes, sir.
And which one do you want to choose?
I wonder if we can confirm they actually have matching tattoos. Or... Curiosity.
Your Honor, he's asking for conditional release.
Congrats to the conditional release. Mr. Eubanks, the other thing we're going to do is I'm going to ask the jail to give you a notice for your felony court date, which will be October 7th at 8:30. Mr. Eubanks, they'll give you that notice, put it in your hand. You will not get anything in the mail. So make sure you're in felony court October 7th at 8:30 to see Judge Garcia. Do you have any questions?
No, sir.
All right, sir. We'll see you at the courthouse. You'll get to use the phone before you leave the jail. The jail staff will then bring you to the courthouse. So if you do call friends or family, tell them you can be picked up here in roughly 30, 45 minutes. And you'll meet with the conditional release officer before you leave, okay?
Yes, sir.
Busy morning for Wade Mercer. Much busier than what he normally has on a Tuesday. But we're going to move on. Let's go to Texas Judge Stevens, where the world seems to have been turned on its side a little bit this morning.
John?
Yes, sir.
Okay, you're filling out, what is that, an indigent
So
form?
he was here previously, with
I expect people
wanting
to
to
pay for
hire an
their,
attorney, but then he was unable to hire an attorney. And the court staff let me know that he did not have a new indigent form on file, so I was just getting one for his file because they like
Oh.
have an updated one.
okay, so what are you doing about hiring somebody? Are you able to hire somebody?
No, sir, no, it's not.
Why not?
Because the lowest offer I got was 10,000.
The lowest offer
Yes, sir.
for burglary of a building, a state jail felony?
Yes, sir.
I believe he's
You
talking
might go
about,
to, you might want to go to someone else. That sounds a little high.
where's your?
How many people did you talk to? One?
No, sir, I was offered 10 people.
How many?
10.
And the lowest offer is 10 grand for a state, for helping you on a state jail felony?
Yes, sir. Actually, I think the lowest was 75. Yes, sir.
Do you have any prior convictions? And this is their first offense?
Yes, sir.
Color me amazed. That doesn't sound realistic at all. I know what's going on out there, but that's not realistic. She knows what the temperature of the business is out there, but first offense without any prior convictions on something like that, unless it's going to be taken to trial. I mean, if somebody's insisting on a trial, which is what you have a right for, then that might be different. But these are kinds of things that generally don't get worked out. Don't work out that way. They work out in a pretty quick disposition. If you've never been in trouble before, there's a way of making a mistake and then getting it fixed without a conviction.
Yes, sir.
Is there any loss here?
Yes,
Is there damage and
there's
loss? Is there a lot of them? Is there a lot? Oh,
we have offers in both cases. I just have not had a good contact number for Mr. Poole. He's gonna call.
does he
my
have one
office.
now?
I have one now. We have potential resolutions in this case. If I could just have 4 weeks to talk with him about that and try to get something moving in one direction or the other. I believe this would be a resolution, Judge.
It would make sense. It's just hard to believe that's that's the temperature of the cost for something like this under these circumstances. There must be something else I don't know.
There are two cases, Judge. He has two different offenses. And there is restitution in both cases. We have relayed the offers to Ms. McNally.
What are the? It's 14,000 on this one, it looks like.
The other one is around 5,800, Your Honor.
Well, where's the stuff? Was that returned? Is that returnable?
I believe some of it was sent to the scrapyard and then taken off, so I don't believe that they're.
Is there anything returnable?
I think it would have to be in the form of restitution as reimbursement instead of. We're working on it.
Well, that adds to the cost of everything.
I hate when he does that. I don't get him sometimes. Let's go to Judge Boyd. She was off last week. She's back. Let's see what's going on.
Are you Paul Anthony Ramirez?
Yes, ma'am.
Okay, on this case, could I have the original motion to revoke?
Yeah.
I only have the first amended. Okay, thank you.
Yes, ma'am, sorry.
Mr. Ramirez, did you review the motion to revoke community supervision and first amended motion to revoke community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Paul Anthony Ramirez who was placed on community supervision in 2024 CR 009393 for the offense of possession of a controlled substance penalty group 1, 4,200 grams on October 31st, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Paul Anthony Ramirez did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
No
Any
objection.
objections?
No objection, Your Honor.
Do you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor. Is to grant the state's motion, revoke the defendant's community supervision, reform his judgment to a sentence of 3 years in prison. And the state is going to take into consideration cause number 2025 PF 31486 and 2025 PF 31487.
All right, and what are those allegations in those?
It's an unauthorized use, Judge, and a possession condition.
All right. So what has he done on probation other than pick up new cases?
Your Honor, the times that he had missed, and it's, we have waived, those allegations obviously have been waived, but if the court looks at the MTR, he was in Medina County for another offense.
All right.
Fundamental.
So was he ever released while he was on probation?
You did report some of this, correct?
Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Anthony Ramirez.
All right, so what have you done other than it's alleged that you picked up 2 new cases?
I reported like 3 or 4 times. I paid those times that I did go report.
All right, so you've reported 3 or 4 times since October 2024.
Whenever I was released from here, I reported like 3 times, three times.
So why are you only reporting 3 times?
Because after that, I was in Medina County.
And in custody in Medina County for what?
Unauthorized use.
All right. And is that an unauthorized use that's alleged to have been committed after he was placed on probation?
My understanding is yes, Your Honor, but out of an abundance of caution, would just simply ask the court, or if we have the summary here, I'd like to, just take a look at the dates just to make sure, but I am pretty sure it was after.
Yes, sir.
That was after the new charge after you got released.
Yes, sir.
So then here's my question for you. Why should I give you less than what you bargained for when the only thing you've done is report 3 times and you picked up a new case, you ended up in Medina County, and then you have 2 new charges here that the state is taking in consideration? And I'm assuming those 2 new charges, was that after he was placed on probation?
Yes, Your Honor, they were August.
So why?
Well, these cases didn't have nothing to do with me as far as the unauthorized use.
Okay.
How it all happened is, if you look into it, but
And what were Your Honor, on the unauthorized use here, basically he was with but I would think that the evidence would suggest, I don't want to put words in about, the evidence would suggest that the actual taking of the vehicle was by another young lady in Corpus Christi that he had an engagement with here in Bear County that may or may not have involved provable possession of illicit substances, Judge. But it's not, but in no way are we trying to represent to the court that it's acceptable behavior as while he's on probation. We would ask the court to, though, give some consideration, even though we've been here before. This is a young man who's basically been raised in prison. He went to prison for the first time at, I believe, 14. He had some issues with his decision-making, Judge, but with the underlying sentence of 4, we think, well, that's the plea bargain process, and so we think the 3 would be fair, but we would yield to the court on that. The other thing that could be done at this time, if he didn't have the cases pending in Medina County, I will say the first thing that came out of his mouth is that he needs help with his, would you agree? Help with I'll let you complete my sentence.
with that, Judge,
Well,
I really do need. Just okay, good. I really need help with the substance abuse. That's the whole point of it. I'd rather have take the 3 years of TDC just to. Overall, I think it'll help me out than to just go out and do the program, whatever it is.
But I mean, you were given a chance when I placed you on probation to get it together, right?
The problem is the drug problem. I was still.
Oh, no, you could have came here and I would have said, okay, let's take care of your drug issue. Let's give you whatever help you need with drug issues. But you didn't reach out to your probation officer. You didn't reach out to the court. You reached out to take a ride with somebody in a stolen vehicle. And the last time I saw you, did you have the teardrops or is that something new?
No, same thing.
All right. And then the crown.
All the same.
And then the Playboy bunny.
Everything.
And then the $sign.
It's all old.
Yeah. How old are you?
28.
All right. You're 28 years old. And you went to prison when you were 14. TYC, that's what we would call it.
TDC.
Is somebody sending somebody to TDC at 14?
I think Your Honor, given.
No, I mean, you start out in TYC. They're not sending 14 years old to prison. Then once you become of age, then they will send you to prison. So I can see you.
Sentenced at 14, then 15, I was in TDC, the Clemens unit, YP. From all the way till I was 21.
Well, is somebody going to sue Texas for sending a 15-year-old to prison?
Your Honor,
I'm always interested in learning new law. There are a lot of defense attorneys in here. Do they send people in Texas to adult prison when they're 15?
Your Honor, I think that just sometimes, okay, and again, not to contradict what he's saying, but I think sometimes it just kind of blurs and runs in together when you've been in since you're 14.
Well, let me just tell you this.
I can tell you this, there's so
Any legal advice, but if you were sent to prison at 15, somebody needs to file a suit, although the statute of limitations may have ran since you're 28. But this is what I can tell you.
and for the record, Your Honor, obviously, I did not represent him.
No, I appreciate that.
For people in,
This is what I can tell you. At some point, your actions are your own. You can't keep blaming your actions on the fact that you went to TYC at 14. You got to change your life. All right. I'm going to follow the agreement that you worked out based upon what your attorney is saying and what the state is saying with regards to the unauthorized use. I guess that's what we do since the time of Adam and Eve. We still blame the woman for our own actions. So, are you waiving your right to appeal?
Yes, ma'am.
All right, the court is going to sentence you to 3 years in the prison, give you credit for any time served. I'm going to request the therapeutic community. There's to be no unsupervised contact with minors, no residing with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
Right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. When you're released from custody, if you can't find somebody to help you get on the straight and narrow, if I'm still here, you can come back here. I'll find an inpatient treatment facility for you. Now, let me just explain to you, the reason why I'm saying no unsupervised contact with minors and no residing with minors is because you really shouldn't be around minors because you'd be a bad influence. And until you get your life together, that's the way it should be. And a lot of women will see you when you come out of prison and they're going to see somebody who's a good catch.
Yes, ma'am.
And we can't have that until you get your life together, okay? All right, good luck to you, all right?
Okie dokie, let's stay in Texas, but we'll head east to west.
The Musgrove. And in cause number 25 DCCR 0048, Ms. Musgrove is charged with murder, set for trial to begin with jury selection Monday the 29th. And what is the announcement?
So, Your Honor, a couple of things. So, we just recently received an offer, or a new offer, from the state. There is a cell phone extraction that was performed a couple of months ago. It is a voluminous amount of materials. We're still reviewing that. So if we could just have one more reset just to finish reviewing that, I think we're close to a resolution.
So why is it on the trial docket then?
Originally, that was, they said they didn't want an offer and wanted to proceed.
Right.
I think it had to do with the theory of their case.
Okay.
So because of this new offer, which we're heavily considering.
So here's what I'm going to do. I'm going to reset it. I'm going to take it off the trial docket. I'm going to reset it 45 days for a review.
Perfect.
And at that point, if there's something that gets worked out, it needs to take place on that day. Otherwise, it will go back on the trial docket and it'll be ready for trial.
Yes.
Is that good, Mr. Nichols?
Yes, sir.
Okay. All right. You can go back with the bailiff.
All right, thank you.
45 days on a review.
So she's starting her day off with a murder. That's fun. Back to Boyd.
And are you Alicia Rubio?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alicia Rubio who was placed on community supervision in 2022 CR 3602 for the offense of assault family household member with a previous conviction on June 30th, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, violation of condition number 39. On or about the third day of January 2025 in Bear County, Texas, the defendant, Alicia Rubio, who then and there failed to attend felony drug court evaluation in violation of condition number 39.
How do you plead to that? True or not true?
True.
State will waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition 39, the court could find it true, grant the motion, and sentence you to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 39?
Yes, ma'am.
Court will find violation of condition 39 true. Is there a proposed agreement?
There is not. That is to deny the motion. Alter and amend the defendant's probation conditions to add DDRF followed by DDRF aftercare.
That is our understanding, Your Honor.
Why should I do that?
Your Honor, my client definitely needs help. She's had a lot of mental health issues and depression. Her father died, and she just basically didn't even get out of the house and did not follow any of your terms of probation, but she does want help, and she needs the help. And the state and probation wants to help her, so we're asking you to do that.
All right, so this is not the first motion to revoke she's had with me. Has she done anything on probation?
She's done some community service hours.
In all my communities.
Other than that, I don't see what's a lot.
All right, probation, what has she done?
Judge, I would have to look into the community service hours part of that. But the only thing that I have that she has completed was basically her TAP evaluation. She did her DNA testing and there's a $90 credit on the account.
I mean, she hasn't done anything, and we've been here before. And the court recommended felony drug court for her because we had issues with drug use. And nobody can help anybody who doesn't want to be helped. She was here December 2024 for a violation of condition number 4, not reporting, disappearing. I denied the motion, alternate amended conditions to include a TAP evaluation out of custody, a mental health evaluation out of custody, and a referral to felony drug court out of custody. And then she disappeared, and she's been missing since January. So it's obvious to the court, there's nothing that I can do here. So I'm going to grant the motion and revoke. Do y'all want to recommend amount of time?
Stay with you 4 years.
Defense.
Your Honor, my client, she has 209 days credit, but my client is asking for you to consider reducing that amount to 2 or 3 years, Your Honor. Not to make excuses, but the gentleman that you had before picked up new cases and he
All
gets
right,
3
so
years.
here's the thing. Let me explain something. And defense attorneys will tell you this all the time. And I used to have clients, they said, well, this person got that. Why can't I get this? Or this person got that. Why can't I get that? I treat everybody as an individual because guess what? If I didn't treat everybody as an individual, everybody comes before me. And usually, you know what they tell me? Somebody died in my family. I just got a job yesterday. And if I didn't treat people as an individual, you know what I'd be doing? All those stories that people tell me, sometimes they're true, sometimes they're not true, I would hold it against you. So what somebody else receives may not be for you.
Right.
So I'm just looking you at an individual and you're looking at 4 years because that's your range. And what I can tell you is the person who just came before me, because your attorney brought it up, they didn't have a previous motion to revoke.
Right.
So this is your second motion to revoke. And you're coming before me, and I tried to help you with the MIC evaluation, which is what everybody's saying you need. I already tried that. You didn't want it because you didn't do it. I tried helping you with your drug issue. That's why I had felony drug court. You didn't want it. You didn't show up.
Right.
I tried helping you by giving you a TAP evaluation if you were not accepted in felony drug court. You didn't want it because you didn't show up. So the state is asking for 4 years. Yes, the state is asking for 4 years. Your attorney is asking for 2 to 3 years. What I can tell you is I'm not giving you the minimum because you didn't do anything. And this is your second motion to revoke. So you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Alicia Romeo.
All right, what would you like to say or defense? Would you like to speak to her before she speaks to me, or?
I believe she wants to state why you should give her, the 3 years, Your Honor. And I'm going to allow her to speak her mind.
With all due respect, Your Honor, I'm requesting your leniency, yes. But I did do my Zoom, my TAP evaluation through Zoom. I did that. I can't pinpoint the exact date, but more or less, it was before the first MTR. I did that through Zoom.
Mhm.
Y'all couldn't find it the first time I came through here, which is why you recommended the second one. Okay, I went through 4 probation officers, 4 different probation officers while I was out there. My last one was Mrs. Spence. I did my parenting class that y'all requested. I did my community service. I recorded my change of address.
Did you turn in your parenting classes to them?
Yes, I did.
Probation, can you look to see if you have documentation of parenting classes? Continue.
I had, my sponsor, I gave her my sponsor's information. I gave her,
Everyone, please whisper. You may continue. Sorry about that.
thank you. I gave her the information to the program that I was working in San Antonio at Zapata. I gave her all that information. I was doing my meetings at 2:00 and at 6:00 every day. She had no record of that when my paperwork got to her. And I hold myself accountable for missing and not and failing to report. That was my irresponsibility. I agree to that, yes. My depression was something I couldn't control. I wasn't on my medication. I didn't have the strength to leave my house. You know what I mean? I'm not saying that's anybody else's fault but my own. You know what I mean? I'm trying to learn to hold myself accountable, so I'm doing that. I do have a drug problem, but I have been clean. My drug of choice is heroin. I have been clean off of that since I picked up this charge, because my priority is to get back to my mother, especially since I lost my father in March. I want to be with her. I want to grieve with her. I want to do all of that. That's why I'm requesting your leniency. You know,
All right, so here's the thing. I don't know if you've been clean or not because nobody's tested you. You're just telling me this.
The last drug test you requested from me, I was here in your court. It was the same thing. You didn't believe me, and I said I was, and you sent me to drug court to drug test, and my drug test came back clean. You know what I mean? I hold proudly that I'm from where I'm from, and I've been clean. That's something I work very hard to do every day. Because as an addict, that's difficult, especially when I'm grieving the father, my father's loss, or losing my father. I apologize.
You've
That
been
was
missing.
nothing to do.
Here's the thing. You've been missing since January. So I don't know what you've been doing. That's the problem.
And I take that was
my responsibility. Again, I'm just asking for your leniency. I want to get back to my mom.
All right, probation, do you have proof of the parenting classes? All right, this is what the court is going to do. The court is finding violation of 39 true. Court is going to grant the motion. The court is going to sentence you to 3 years in the prison. There's a $1,500 fine, time and money to run concurrent. There's an affirmative finding of family violence. There's to be no contact with Ophelia, Ofelia, Ribiel. Give you credit for any time served, and the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney, counsel?
Yes, Your Honor.
You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on community supervision. Because this is a felony conviction and a finding of affirmative violence, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. With regards to the therapeutic community, it doesn't increase the time that you're in custody, but that can help you with any drug issues or mental health issues you may have. Once you're released from custody, if you cannot find a sober living home or somewhere else, just let the court know. If I'm still here, I'll pick up the phone, call somebody to help you, all right? All right, good luck to you, okay?
I have a question, so I'm gonna exit Susan.
She's a no
She's my
contact.
victim.
She's a no contact.
Oh, no, you have a no contact order with her.
Even after I get out?
Yes.
I'm just right.
All right, are we ready on anyone else?
Down.
All right, well, while she looks for the next contestant, let's continue hopping around Texas. We'll go back to Judge West.
Yeah, pull it down so I can hear you better for now. Thank you. And Mr. Jackson was previously in court in cause numbers 24 DCCR 1669 and 25 DCCR 0189. Entered pleas of guilty on each of those cases of driving while intoxicated, third or more. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
We have, Your Honor. Yes, sir.
Are there any additions or corrections?
No, Your Honor. Not from the state.
I guess this is just somewhat lucky because one happened before the other one was. All right, Mr. Jackson, I'm going to follow the agreement that you made with the district attorney. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. I'm going to find sufficient evidence in each case to find you guilty. In cause number 24 DCCR 1669, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that. You'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes entering and successfully completing the safety program. In cause number 25 DCCR 0189, also find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. Sentence you in accordance with that agreement to a term of 10 years in prison, but suspend that, place you on probation for 10 years. You're also ordered to pay a $500 fine in that case and follow all of the rules and conditions of probation, including entering and successfully completing the safety program. If you do everything that you're supposed to on these probations and you're successful, then for all practical purposes, your case here in court is over. You'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation at all, you can be brought back into court and you can be facing that 10-year sentence that you've already agreed to. Do you understand? I only have one of, I don't know if y'all can get to it. I need the certification in 1669. I'm going to hand you the trial court certifications in each case that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's okay. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir, and we'll get that other copy in a little bit. That's just pro fill out one. We'll get it. He has the one. Can you make a note?
All right, let's change things up. Excuse me, I'm so sorry. I have a low-grade cough that just does not want to give up. Let's go to Louisiana. Haven't been there yet this week. Let's see what's going on.
Panel at headquarters in Baton Rouge. Today, serving on the panel to my left is Chuck Tillis. To my right, Carolyn Stapleton. I'm Jerry Ledoux. We are seeing an offender at Ascension Parish Jail, but before we do that, we're going to have our staff introduce themselves.
Jason, Sherelle, Carla Williams, Whitney Trosclair.
Is there anyone there at Ascension that can identify themselves as being on staff?
Yes, ma'am. Corporal McGowan. I don't know if you can see me.
Thank you very much, Corporal. Okay, now I'd like for the offender to please state your name and your DOC number for the record.
Craig Herbert. I don't know my DOC number.
Okay, let's see. Just a minute. So tell me, what is your date of birth?
9/9/1990.
And do you know, let's see, the last 4 digits of your social?
7767.
Okay, so your DOC number is 726-788. Okay, Mr. Abear, what's going to happen today is we're going to be reading some allegations against you and getting your plea of guilty or not guilty. Do you see a parole revocation questionnaire in front of you? Has he been shown that document? We can put it on the screen if necessary. Sir, look at this. Do you recognize your signature on this questionnaire?
Yes, ma'am.
Okay, that indicates that you're not eligible for appointed counsel. Have you hired an attorney?
No, ma'am.
Okay, we'll proceed. We're going to ask Mr. Tillis to read out your allegations, and then you're going to give him a plea of guilty, not guilty, or guilty with the statement. Mr. Tillis?
Good morning, Mr. Herbert.
Good morning.
You violated rule number 4. You were alleged to have been involved in criminal activities as evident by your arrest on 7/24/2025, where you were charged with the offense of domestic abuse battery, aggravated battery, and domestic abuse battery strangulation. How do you plead? Guilty, not guilty, or guilty with a statement?
Not guilty.
Not guilty. Okay. You violated number 10. You're currently in the following area. Process fees of $65. What is that? Sex text fees of $165 and supervision fees of $1,005. How do you plead? Guilty, not guilty, or guilty with a statement?
Not guilty.
Okay. I'm handling your case, so let's talk about number 4. Tell me what happened. You say you're not guilty of these charges.
It was a misunderstanding. I didn't hit her or strangle her or any of those things. I just restrained her, just was restraining her from hitting me, and it just got blown way out of proportion. I'm sure y'all hear it all the time, but I really did not do this. Like,
Your girlfriend or just someone, a friend?
Yeah, a long time girlfriend.
Long time girlfriend. And you didn't violate any of these charges?
No, sir.
Okay, and what about number 10?
I was actively paying them. You know, I was working and paying my fees. I don't know how it got to be, you know, that high, but I was still paying them every month.
Supervision fees of $1,005.
I was paying it monthly.
Okay, Jerry, are you gonna have the,
Aye.
okay.
Well, at this time, we probably would like to hear from Mr. Devin McGrew, who is the supervising agent. Mr. McGrew, were you with us today? Thank you.
Yes, ma'am. Good morning.
I noted in your notes that Mr. Herbert had been sanctioned twice already during this period of supervision. You want to tell us a little bit about this?
Yes, ma'am. The original one was a failure to report for intake warrant. That was handled. He called, he rescheduled an appointment. There was a confusion in that. So that wasn't a major sanction. That was something that we handled quickly and easily. Excuse me. And then there was a misdemeanor arrest in August of last year for a failure to appear.
So can you enlighten us about what you know about the current situation?
The current case is currently being handled by the 23rd Judicial District. As of this morning, the latest update we have is that he is set for arraignment on those charges, and that the district attorney's office says that there's no intention to drop those charges at this time.
Thank you. We appreciate you being with us and providing that information. Anything else you'd like to add?
No, ma'am. I'm simply here if y'all have any questions for me.
Okay, thank you.
I was just reading that they found that probable cause existed for violation of condition 4 and 10. And then they do have pictures. They have pictures of you too, sir. But they have pictures of her that is stating that backing up what she states happened to her. And then, of course, the DA is going forward with the charges.
Mr. You have any other questions? Or?
From what I was told, that she had tried to drop the charges, that she had dropped some of the charges, or the charges was dropped.
Well, the law is that only the state can drop the charges. So if they find enough evidence, they can choose not to allow her to drop the charges. She may have tried, but the state brings the charges in domestic violence cases. Just like just like when you rob a bank, the bank can't drop the charges. The state brings the charges, or a car wreck, stuff like that. There's certain things that the state brings the charges. And domestic violence is one of them, because it's very common for a victim to be fearful, or for a lot of other reasons, to want to drop charges. And so long, some years back, it was changed so that the victim does not bring the charges, therefore they cannot drop the charges if the DA does not agree.
So, Mr. Tillis, do you have any other questions?
No, I have no more questions.
Is the panel prepared to vote? Yes.
I am, yes.
Okay, Mr. Tillis will be voting first.
My vote today is to revoke due to violation 4 and the evidence that we have.
Stapleton.
I concur, Mr. Tillis.
And my vote is also to revoke your parole. So today you have been revoked. Thank you very much.
Denied.
Now 8:57, and we'll be signing off at Ascension Parish. Thank you, staff, for assisting us.
Yes, ma'am.
Louisiana Board acting as the Louisiana Board typically does. Let's go back to Florida, spend a few minutes with Judge Anna Garcia.
Enter a plea of no contest to the charge of sale or delivery of controlled substance. The plea offer from the state, subject to your approval, is adjudication withheld, 48 months probation, court costs and fines, 100 hours public service work, $20 cost of supervision, drug and alcohol evaluation and counseling. She stipulates to the facts in the affidavit. She understands about the costs for the state attorney's office and agrees to a DNA sample and to forfeit the seized items.
Ms. Long, she's entering a plea to possession of a controlled substance. All right. And Ms. Long, is this what you wish to do?
Yes, ma'am.
All right. If you will, please raise your right hand.
Ms. Long, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Tell me your full name for the record.
It's Rashonda Monique Long.
Did you hear what Ms. Simpson said?
Yes, ma'am.
Is that what you want to do?
Yes, ma'am.
Have you, has anyone promised you anything other than what she said to get you to enter into this plea?
No, ma'am.
Is anyone threatening you?
No, ma'am.
All right. I have in front of me a 2-page plea form. This is the first page. This is the second page. Did you sign that document right there?
Yes, ma'am.
Did you have enough time to review the document before you signed it?
Yes, ma'am.
Did you have enough time to talk to your attorney about your case and about your plea?
Yes, ma'am.
Are you satisfied with her advice and counsel?
Yes, ma'am.
Do you understand that by entering into this plea, you are giving up your right to go to a trial where the state has to prove the allegations against you?
Yes, ma'am.
Do you also understand you're giving up your right to present any defenses you may have?
Yes, ma'am.
And do you understand that you're giving up your right to appeal anything except an illegal sentence?
Yes, ma'am.
Are you doing this of your own free will?
Yes.
And does the state or the defense know of any exculpatory DNA? State?
The state's not aware of any, Your Honor.
All right. And Ms. Simpson, you stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
All right. Ms. Long, I find that your plea is knowingly and voluntarily entered into after the advice of counsel, and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Ms.
Okay.
Long, in Jackson County case number 25 CF 64, I accept her plea of no contest to 1 third-degree felony count of possession of a controlled substance. I will withhold adjudication of guilt, sentence you to serve 48 months state probation. During that time, I order you to pay court costs, fines, and fees in the amount of $1,100, serve 100 hours of community service work, pay $20 a month for costs of supervision, undergo a drug and alcohol evaluation, and complete any recommended counseling. It is important that you understand that there will be zero tolerance for the use of drugs or alcohol, and you will be subject to random urinalysis at your own expense.
Yes,
I order you to forfeit all items seized and to submit to a DNA sample. Are there any additional rulings requested from the state or from the defense?
Nothing further, Your Honor.
All right, Ms. Long, I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Ms. Long, do you have any questions for me?
No, ma'am.
All right, Ms. Long, I need you to step to the side, meet with state probation, and then you will be free to go. Ms. Simpson, Peter, I'm going to get you right after Ms. Simpson's done, okay?
I got Mr. Batson.
All right, Mr. Batson, good morning. Mr. Batson, all right, give me a case number. He's on the out of custody?
24-489 CF.
All right, give me 1 second. Let me get to that. All right, this is Demetrius Allen Batson, case number 24 CF 489. Mr. Batson, please listen carefully to Ms. Simpson, okay?
Okay.
Your Honor, we've negotiated a plea of no contest to resisting an officer without violence, a misdemeanor, assault on law enforcement officer, 3 counts, all misdemeanors. The plea agreement, subject to your approval, is he had been adjudicated guilty, sentenced to 180 days, concurrent to each other at the county jail. He would get court costs and fines imposed and reduced as a civil judgment, get credit for 85 days. He stipulates the facts for the basis of this, forfeit seized items, and
Thank you. Give me 1 second. What did you say? This is the agreement? All right, are you aware of any exculpatory DNA? Is the defense? Mr. Batson, you wanted to say something?
Yes, ma'am. I just wanted to know if I could get my property back because those are heirlooms. That's like those knives are my granddad. They belong to my granddad. What they seized at the time of my arrest. And my book
Because
bag.
it was with violence originally, it is unlikely, but what's the state's position?
Could we be objecting to that? I mean, they were in a backpack that was on his possession after the event, but we're objecting to it.
Okay. The state is objecting to release of property. Would you still want to proceed with this plea? The plea, part of the plea requires forfeit the item seized.
Okay.
You still want to proceed?
Yes.
Okay. Give me 1 second. All right, Mr. Batson, if you don't mind, please raise your right hand, sir. Sir, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Tell me your full name for the record, sir.
Demetrius Allen Batson.
Did you hear what Ms. Simpson said about resolving your case?
Yes, ma'am. Also, I wanted to ask one question. Can I get trustee game time since I'm being sentenced?
What says the state?
I don't have any objection to that.
All right. So we will recommend that you be screened for trustee.
Okay.
Just because I recommend it doesn't mean the jail will accept you.
Okay.
You have to get accepted to
Okay.
that program. Okay.
Okay.
So it depends on behavior, charges, all that kind of stuff, but we'll recommend it. Okay. Mr. Batson, you heard what Ms. Simpson said. Is this what you want to do?
Yes, ma'am.
Has anyone promised you anything other than what she said to get you to enter into this plea?
Well, yesterday they told me that I was gonna get out on the time served,
Okay,
but they changed the plea this morning.
and that can change at any moment. They
Okay.
can technically change it right now. They normally don't do that once
Right.
we've started this colloquy, but before we even start the colloquy, they could say, hey, please off the table.
Yes,
All right, but other than what she just said, I mean, you understood that you're pleading to 180, correct?
Yes, ma'am.
All right. Is anyone threatening you in order for you to do this?
No, ma'am.
I have in front of me a 2-page plea waiver and consent form. This is the first page. This is the second page. Did you sign the document right there on the second page?
Yes.
Thank you. Did you have enough time to talk to your attorney about your case and about your plea?
Yes, ma'am.
Do you need any more time to talk to her privately? Do you understand that by entering into this plea today, you are giving up your right to go to a trial where the state has to prove the allegations against you?
Yes, ma'am.
Do you also understand that by entering into this plea today, you are giving up your right to present any defenses you may have?
Yes, ma'am.
And do you understand that you are giving up your right to appeal anything except an illegal sentence by this court?
Yes, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
All right. Mr. Batson, I find that your plea is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Mr. Batson in Jackson County, case number 24 CF 489, I accept your plea of no contest to 1, first-degree misdemeanor count resisting without violence. 3, first-degree misdemeanor counts assault on Leo. I adjudicate you to be guilty of all 4 charges, sentence you to serve 180 days in the county jail with credit for 85 days that you've already served towards that sentence. I order you to pay court costs, fines, and fees in the amount of $732.50. $732.50. Those will be reduced to a civil judgment, and I also order you to forfeit all items seized. I will recommend you for the trustee program, and there may be some additional game time that you are able to get for being in the trustee program if you are accepted.
Okay.
I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Okay?
Okay.
All right. Good luck to you, sir.
Thank you.
Thank you.
All right, thank you.
The other 2 I have, you signed at the jail, Baxter Holden, 225, 236, and 225-242.
All right, let's go back to Texas. Judge Boyd has another contestant approaching.
Oklahoma. $6 million for arching. A lot of money.
So has the state tendered an offer?
So Judge, what's happening is there is an unindicted case that the state is going to try to get the file for. If we can do a week, I think we're working at a deal on the new case. This current case, the ag assault and the other ones, I think are going to end up getting dismissed through lack of contact with the complainant. But there's an unindicted felon possession we just found out about.
All right, Ms. Ferguson, I need a 1-week reset. All right, September 23rd. All right, we'll see you back then.
All right, thank you, Judge.
You're welcome. Yes.
All right, that was fast. Let's go back to Judge Garcia.
At this point, Judge, maybe just coming back in January,
The only issue is, of course, we're waiting on Mr. Vereen in the other case to get moving, so that way we can, get Mr. Young's case to a conclusion as well.
And that's hired counsel, correct? That's not appointed.
That's correct.
Correct.
Okay. All right. Well, then,
I've previously waived, so no objection to that. I advised my client that it was going to be a lengthy process. And we know the end game we're playing, Your Honor. So January pretrial is fine with us.
Mr. Overstreet, you agree?
Yes, Your Honor.
All right, let's do January pretrial, January 20th at 9 a.m.
Thank you.
For Mr. Young. Mr. Overstreet, do you have any additional cases this morning with us?
I do not, Your Honor.
All right, well, thank you for joining us.
Thank you so much. Have a great day.
All right, you too.
See you.
Mr. Blunt, who you want to call next?
Your Honor, I call Mr. Michael James Clark, case 24451 CF.
All right, Mr. Clark, good morning.
Good morning, ma'am.
Mr. Clark, Mr. Blunt, how's it coming?
Your Honor, the case is coming along. However, there's been some other stuff that has come up based on my discussions with the state yesterday. I would ask for the October 21st pretrial date on Mr. Clark, and there may be a possible motion on Mr. Clark's behalf that I would be filing for the October 9th, but I would give notice and ask for that date as I get closer.
Okay.
There's something he and I need to discuss as far as a possible motion on an issue related to the case. I'm unclear. I think he is possibly set for the.
Sorry to interrupt. I have to take care of something a minute. I'll explain, but just ride with Judge Garcia, and I'll be back in a few minutes.
He is set there. What says the state?
Your Honor, I don't have any objection to removing him from the October trial date. The state has done a motion to compel fingerprints. I did discuss that with Mr. Blunt yesterday, but I don't think we noticed it for today. So I would like to add him to a docket to handle that motion for fingerprinting.
The 9th?
If we could add him to the 9th, that may work out for everybody.
Sure. Now, is your motion, do you anticipate it to be a lengthy motion? Just give the state enough time to respond and all that.
It may be, yes, ma'am.
Sure. And if we need a special set day, then we can
Yes,
do
ma'am.
that too.
All right.
Okay.
Thank you.
All right. October 9th then for motion. Specifically, ladies, right now, the motion to compel fingerprints. However, there may be, and Mr. Blunt can add whatever additional motion he wants. State, just let us know if you don't have enough time to respond.
Thank
Thank
you,
you.
Your Honor.
Okay.
That'll work.
All right. Thank you, sir. See you then. Thank you. And off the October 27th trial. Go ahead, Mr. Blunt.
Your Honor, I have some at the jail. Mr. James Boutwell Jr., case 25166 CF. Oh, here they come. Mr. Boutwell. Can they hear me?
Come on.
I seen him walk by.
James Patrick Boutwell Jr. Mr. Boutwell, good morning. Are you able to hear us and see us okay?
Yes, ma'am.
Excellent. Mr. Boutwell, Mr. Blunt is here with me. And this is James Patrick, correct?
Ma'am, James Patrick Boutwell Jr., case 25166 CF. We're here for a pretrial, Your Honor. This is his first pretrial on the case. I've received discovery. I met with Mr. Boutwell at the jail. I did receive an offer from Ms. Jeffcoat. However, I've been unable to go over that with Mr. Boutwell. So I would ask that he be set for the October pretrial date.
What says the state?
No objection, Your Honor. I just sent that plea offer yesterday, so.
All right, Mr. Boutwell, I will see you at the latest on October 21st. Mr. Blunt, if he wishes to take that offer sooner, I can always get the case brought up
Yes, ma'am.
sooner. All right, Mr. Boutwell, we'll talk to you then.
Yes,
Your Honor,
ma'am.
next I have John Coates. It is case 24546, 24548, and 24549.
Good morning, Mr. Coates.
Morning.
Mr. Coates, listen carefully to Mr. Blunt.
Your Honor, I went through some of the discovery with Mr. Coates, advised him kind of where we're headed in game wise. I may have to do a motion on his case. I would tentatively set him also for the October 21st court date, but I may move the court to be able to for limited purposes, depose the alleged victims in this case. There's two of them that I have been unable to depose. One is an adult. I deposed her. However, the two juveniles I may need to depose, but I would file the appropriate motion before the court and let the court hear it and give the state an opportunity to be heard.
All right. Any objection to proceeding in that manner from the state?
No, Your Honor.
All right, then, Mr. Coates, we will see you then at the latest, okay?
Thank you.
All right, thank you.
Your Honor, next, Christopher Harrison, case 24-195 CF.
Mr. Harrison, good morning.
Good morning.
Listen carefully to Mr. Blunt.
Your Honor, Mr. Harrison's in kind of the same situation as Mr. Coates. There is one witness that I need to give to the state for them to possibly depose. However, I likely need to file a motion asking the court to allow me to depose the victims in the case.
What says
So
the
I would-
state?
I'm sorry.
Oh, go ahead.
So-
No objection to the continuance, Your Honor.
So I would ask since him and Mr. Coates are similar, October 21st, Your Honor.
Both for October
I
21st?
believe he's set for a trial also in January, so we're tracking that trial date.
All right. So in light of that, then October 21st then will be the continued court date for Harrison. We'll see you then at the latest, sir.
Thank you.
All right, thank you.
Your Honor, Mackenzie O'Brien's case 25-50 CF. I went to see her at the jail. However, I was made aware from the jail that the feds had picked her up. So
Oh.
she is currently in federal custody with her co-defendant in that case.
Anyone know when her next federal court date is?
Have no clue. They only picked her up about a week and a half ago.
You want to go January 20th and
That's
kind of
fine,
see
Your
where we are on that case? January 20th at 9 a.m.
Yes, ma'am.
And let's see where we are.
Your Honor, next I have Justin Sarsfield, case 23-248 CF. He is currently in the Holmes County CI. I went and visited with him Friday of last week. He had been self-representation and I was appointed to represent him. So I had provided discovery. Some of it he got, some of it he didn't. The prison staff allowed me to give that to him. I thought he would be on today. I'm going to set him for the October court date, waive his appearance today since I did meet with him on Friday and set him for that. And I will try to arrange for him to be available.
All right, you'll work with Angie?
Yes, ma'am.
Okay, any objection to the October date on Sarsfield? 21 then for a continued court date for Sarsfield.
And I don't know if classification officer, Mr. Wesley, watches any of our YouTube, but I appreciate everything he did in facilitating
They're
that
always great.
visit. He was very nice. Last I have number 63 is LaFrederick Staples, case 22-519 CF. Your Honor, this is one that we had moved to the day. He is currently serving 40 years in the Department of Corrections. I was trying to work this out with Ms. Jeffcoat. We have done depositions in the case. He is currently in South Florida. I would just ask that he be set for a January pretrial date, and then we could see where we're at for the new year, setting him for trial.
What's it looking like as far as his EOS?
It's 40 something or 20.
I thought you said 4. You meant 4D. Got it. All right.
I'm from Wausau. I don't enunciate.
All right, let's
I'm
do
doing good to have my tea.
Derek, stop it.
That's my people's.
I know they. Okay. January 20th at 9 a.m.
Thank you, Jeff.
Okay.
At least my hands aren't soft like Mr. Roberts. But anyway, that's all I have, man.
Why is he messing with you? You're just sitting over there being quiet.
I shook his hand and it was soft. Like, wow, he has been working hard and not in the gym. So I appreciate
Lord.
it. May I be excused?
Yes.
Thank you.
Go. Thank you. All right, who's next? Marcus?
Yes, Your
Honor. Okay.
Yeah, I can.
Is Marcus the last person that has anybody at the jail? Oh, excellent. Let's do that. Mr. Caballero?
Yes.
Stand there. You're good. Marcus, go ahead, call your jail cases.
Cameron McClendon, case number 2453.
Oh, we had him on the out of custody. How's that going with, okay, Mr. McClendon, good morning.
Good morning.
Mr. McClendon, listen carefully to Mr. Green.
All right, the court may recall, we did have a place set and then they changed their mind about being willing to take them.
Because we have a professional guardian now too.
Have a professional guardian, Ms. Beard. I've been in contact with Ms. Beard. She's still trying to find him somewhere. I've also been speaking with APD. They had some concerns. I've got some paperwork together to send them about them. They are just trying to decide what the correct placement is for him within them. And
Is APD going to take him?
they are going to take him.
Good.
Just deciding on the right place.
Okay.
I spoke with them last week and expect to get an answer from them soon. So I would ask to just
Track him to next month. Keep him tracking. Mr. McClendon, we continue to try to get you somewhere other than the Jackson County Jail. Your attorney is working diligently to that end, and we will see you at the latest on October 21st. However, if we have appropriate placement before then, I'm happy to sign a release. Okay?
Thank you. Thank
Okay,
you.
Mr. McClendon, we'll see you then, sir.
Thank you.
next is Randy Southwell, case number 24463.
Mr. Southwell, good morning.
Good morning.
Good morning. Mr. Southwell, listen carefully to your attorney, Mr. Green.
Thank you, Your Honor. Mr. Southwell, I believe is scheduled for trial next month.
We do, at October 27th trial date.
And so,
How long do you need?
It would be a one-day trial, Your Honor.
One-day trial? All right. All right, so then we're still tracking. Do you need an additional pretrial date or no?
no, Your Honor.
State, do you want an additional pretrial date or are you good with just going to the trial date?
I think I would prefer a pretrial date just in case.
All right, October 21 at 9 a.m. is a continued pretrial. Mr. Southwell, I'll see you October 21st, but then we're also scheduled for, wait. Yeah, that makes sense, right? 27.
Yep.
Was that 28? Okay, we'll see you October 21st, and then we have trial on October 27th, okay?
Okay.
See you then.
Hasta la vista.
All right, bye-bye.
Okay, folks, let's take a break from court for just a moment. If you're listening on the podcast side, just bear with us. This is much more visual than audio. But if you've followed us in the pre-show, if you're a channel member, then you're aware that for the last couple of weeks now, here at the TCF bunker, we've been taking care of a couple of baby birds. These are our birds that were in a nest in our neighbor's tree, and the neighbor had cut down the tree, and this nest had fallen out, and Grandma TCF found it on the ground, and we started taking care of them. And this is how they were when we found them, probably no more than 48 hours old at the time. So we have some experience with birds here, and we made up a slurry to feed them with and whatnot. And a few days later, surprisingly, their mother found them and started bringing them food, but we continued to care for them and whatnot. And that was good. So yesterday, about 2 weeks later, this is what one of them had grown into. The other one, you can kind of see its head towards the bottom left of the photo there because it was still sitting down. We'd taken the nest and put it in a tote. But you could see yesterday they were getting a little bit braver, kind of perching themselves up on the side of the tote there, Mom continuing to bring them food. Well, I stepped out of the studio because a little while ago they returned to nature. This is on the neighbor's roof. You can see the two babies up front, and if you look at the peak of the roof there, that is Mom sitting up there. So they have taken flight. We'll leave the tote with their nest in it out for a few days to see if they return at night. But happy to report that the birds have all grown up and started to take flight and move on and hopefully go live a good life. So I just wanted to share that because, again, if you've been following it all in the pre-show especially, we've been looking after them and taking care of them, and it's good to have that kind of success. So happy for the birds. Anyways, just thought I would share that. Let's go to Texas and Judge West.
Good morning. Good morning. Mr. Southwell, good morning. Good morning. Mr. Southwell, listen carefully to your attorney, Mr. Green.
Thank you, Your Honor. Mr. Southwell, I believe is scheduled for trial next month. We do, October 27th trial date. And so
Plea of guilty in cause number 24, DCCR 2330, to tampering with physical evidence. I've received the pre-sentence report. Has everyone had an opportunity to review the report? Are there any additions or corrections?
No, we're good.
In addition to this pre-sentence report, I've also received and reviewed a number of jail incident reports. Has everyone had an opportunity to review those? And you're 19? Why haven't you been acting right in the jail?
Most of the reports are not true. One time I did not uncover my face on video. I did, because I was asleep and she didn't wake me up. Ms. Boa didn't wake me up. When I got here in June.
So she's lying when she says she tried a few times and then she taps you, taps your bed, kicks your bed a little bit.
That day Ms. Boa never tapped me. And then in June, I got in a fight when I first got here. The girl swung at me first.
Okay.
That's accurate what it says, the girl here with the closed fist.
Yeah, I mean, if you get hit first, that's not the one that I'm so worried about. It's the eating at your bunk when you're not, I mean, it's not even big stuff. It's just not following the rules. And if you can't follow the rules in jail, why should I believe that you can follow the rules on probation? When you're in jail, when you're on probation, when you've committed a felony, you don't get to make certain decisions for yourself anymore, right? Now, you're not going to be like every other 19-year-old and get to just do what you want when you want. You're going to have to do what either jail says or what I say or anything like that. If I'm going to follow this agreement based on the nature of the offense and based on the age and all of this, we're going to get you some help up front to be making better decisions. Otherwise, I'm not going to follow the agreement. Things could be a whole lot worse. Do you understand? So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, and I'm going to defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program. You're not going to get out of jail today. You're going to go to ISF instead, and you're going to hopefully pay attention and learn how to make better decisions. You're still young, you're still immature, but you're going to have to make some very mature decisions if you don't want to go to prison. And that's going to be to help you make those better decisions. Now, here's the thing. If you're in our jail and you start before they send you in the next week or two, or if you're in ISF and you are acting up and not following rules, putting something on your head that you're not supposed to, eating where you're not supposed to or when you're not supposed to, talking about whatever it is, I don't care, then you could be revoked just for not following the instructions. And you'll never get out and even have an attempt at probation. Do you understand? So whatever's going on and whoever your buddies are in there, you need to tell them, just sit there, do everything you're supposed to do. All the playing around's done because you want to get out and make something of your life. And if they don't want to, that's going to be on them. If you keep doing all this, you're going to have a felony conviction and you're going to go to prison. It's that simple. You understand? The part of this probation that is so good is that you don't have a conviction right now. And if you're successful and you complete your probation, you are never going to be a convicted felon. So this is a great opportunity. But if you do violate in any way, you'll be back in here, you'll be a convicted felon, and you could go to prison anywhere in that range of punishment, which is between 2 and 10 years. All right? I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Good luck to you. You can go back with the bailiff. Thank you. Let's see, so is it working? I know.
By the way, because I got caught up with the birds, I missed it, and apologies. Thank you, Barbara, for gifting that membership. I appreciate that. Let's go back to Judge Boyd.
Versus Desmond DeBryan Gomez. Could I have parties announced?
Christian Vega for the defense.
And are you Desmond Gomez? All right. We are here for sentencing. Just one moment. All right, Mr. Savage, we're on the record. You're going to have to whisper. That's okay. All right, according to the plea paperwork, it says that you entered a plea of no contest to counts 1 and counts 3. Is that correct?
Yes, Judge. He was running a concurrent, it was a plea for concurrent deferred, and we were recalled for a TAP evaluation and a MIC evaluation. The report-
No, I'm just wondering because the docket sheet says something different. So I just want to make sure that the paperwork is correct. So count 2 was waived?
I would have to look at it, Judge. I'm sorry.
That's okay.
Thank you.
Because I have count 2. Oh, I'm sorry. There are 2 case
Yes,
numbers.
2 and 1. That's
2 and 1. Thank you.
Thanks, Judge.
All right. So you entered a plea of no contest to counts 1, counts 2, and counts 3. All right. And it counts 1 and 3 are third-degree felonies. Count 2 is a state jail felony. And according to your plea bargain agreement, in each case, the state is recommending deferred adjudication. Just one moment. Do you have any objection to the court reviewing the information that probation has sent?
Oh, not at all, Judge.
All right. Have both parties had a chance to review the mental health evaluation and the TAP evaluation?
Yes,
Any
Judge.
objections?
None.
All right. All right, so they're not recommending that he be placed on the mental health caseload. And then with regards to the TAP evaluation, they're recommending residential treatment. Did you want to address that, counsel?
Yes, Judge. Clearly it's within your discretion. There's SAF with aftercare, intensive outpatient with aftercare, and in the event he either anxiety worsened or they due to issues on probation, if there was ever a need for MIC placement, they said they'd reevaluate that. He does not have an extensive criminal history at all, but in addition, regarding drugs, drugs were involved in the offense. He does admit to substance abuse, several serious drugs. I think he could benefit from some treatment, but he has never been on a probation before. So I think intensive outpatient could, I think that would be very beneficial to him. He's been in custody for quite some time. He's not bonded out, and maybe SAF could be held in abeyance while he does do intensive outpatient treatment.
Probation, what are you recommending as far as, I know the TAP evaluation is requesting residential treatment. What are you recommending? Are you in agreement with the lesser modality?
Judge. I think that he has put in place. I would be in agreement with the lesser modality, with the understanding if any positive ways or anything comes up that he would go into status.
All right. And then the other question I have, it mentions that his family's in Beeville.
He does have some family out there. Yes, Judge, but he also has a family in town.
So is he going to be remaining in Bear County?
Yes, Your Honor.
All right. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your
All right, you can lower your hand, state your name for the record.
Desmond DeBrian Gomez.
All right, so I do remember your case. Now that you're before me, do you need a cough drop? Yes, actually. Thank you. Thank you. I tend to remember faces, then I can connect that to the facts that I recall. So, when is the last time you had any type of treatment for mental health issues?
Can't recall, like as far as inpatient or outpatient,
Mhm.
I just have a normal family doctor that has given me antidepressants and other medications just throughout the past maybe 6 or 7 years. Sure.
All right, so when's the first time do you recall seeing a mental health doctor? How old were you?
They no, probably like 10 years old.
Because, counsel, I'll tell you what, even though I know what the mental health people are saying, what I find concerning is your attempt to commit suicide in the vehicle.
Yes, ma'am.
So are you having any contact with your children now or no?
I've been talking to them over the phone, but I haven't seen them in probably since before I had gotten arrested about 6 months ago.
All right, and who is your support system here in Bear County?
In Bear County, my grandmother, and I have two aunts that I talk to over here.
All right, how far did you go in school?
11th grade, and then that's when I had my daughter.
Mhm.
And I just stopped going.
So have you worked on trying to obtain your GED? And have you been successful with that or no?
Still in the process. I was in the process right now, while in custody, and I've tried, but I've just really been hard for me.
All right. Have you had any type of employment before?
Yes, ma'am.
Doing what?
Survey.
Okay. So what I'm going to tell you is I'm going to do, I'm going to start you with outpatient treatment. And you're going to have to really communicate with your probation officer because I'm going to grant your application for deferred adjudication. But these cases, if you're unsuccessful on deferred adjudication, and if a motion to revoke is filed, I'm not saying it could happen, I mean that it will happen, but on the state jail felony, you will be looking at 2 years in the state jail facility, and that's day for day. The other cases that are the other counts that are third degree felonies, you'd be looking at 10 years. Do you understand?
Your Honor.
So you're gonna have to communicate with your probation officer, and your attorney will tell you in this court, if people are struggling with their drug addictions, all you have to do is let your probation officer know. And you know what's gonna end up happening? If they tell me that you're using again, I'm gonna receive a supplemental report from them. And they're gonna tell me that you're testing positive for drugs. And you know what I'm gonna do? I'm gonna set it for a compliance hearing. I'm gonna have you come in, and we're gonna see. And maybe you need inpatient treatment. But if you do this thing and you disappear, that's gonna be a major problem. You understand? All right, so this is what the court is gonna do. Counts 1, 2, and 3 are to run concurrently. There's to be no contact with Olga Cisneros. The reason why I'm doing that is because all of this started because you all were in a fight.
Yes, Your Honor.
I may change that at some point in time, but for now, you need to focus on you. You understand?
Yep.
There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. Take in consideration 2025 PF 13273. There's to be restitution, if any, to Juan Vertiz, Vertiz. James Trottie, Trottie. There's to be the MRT, anger management, 200 hours of community service restitution. The court is going to order parenting classes. Once that's completed, 100 hours will be deemed satisfied. The remaining 100 hours will be deemed satisfied if the defendant obtains his GED or trade school certification. I am going to order the parenting classes, the trade school or certification. That's up to you. Either you can get that done or either you can do 100 hours in the heat of San Antonio. Do you understand?
Yes, Your Honor.
There's to be intensive outpatient treatment with probation and a referral to Center for Healthcare Services and 60 sober meetings in 60 days. Probation, is there anything else? Thank you. Field visits 1 time per month until further notice, and there's to be no residing with minors. Vertiz.
Is Victor boy?
Oh, V as in Victor. All right, and there's to be no unsupervised contact with minors. Is there anything else you need from the court to help you be successful on this probation?
I guess it's giving me everything to think that I need as well.
All right. If you need anything else, be sure and let the court know. Counsel, for some reason, I do not have a copy of the trial court certification.
Okay. We can do that.
So if you could just grab one for me, please. Oh, thank you. 5 years deferred adjudication.
Thank you.
It feels like it's a Monday. This is what happens when I leave for a certain amount of time. Do you know in some places people are on probation for life? I've never heard of such.
Sounds difficult.
And I'm sorry, Vashon, you need to write a letter of apology to James Trotty. You understand?
Yes, sure.
No one likes to be spit upon.
Yes, sure.
So, Ms. Abrams, he's going to write a letter of apology to James Trotty. And state if you have that dismissal from him. It's a 2025 PF 13273.
Oh, sorry, Trevor. Got it myself.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, good luck to you.
Thank you.
You're welcome.
All right, let's change it up a little bit. Let's go to the great state or Commonwealth, technically, of Kentucky. Judge David Williams.
Are they downstairs? They're back here? Yeah. Okay. Okay, well, we'll call them in a few minutes. So Larry Buttram.
Yes, sir.
Commonwealth versus Larry Buttram, 24 CR 0093. Are you Larry Buttram?
Yes, sir.
1973.
Yep.
Last four digits. Revocation. You're represented by Mr. Bell.
Yep.
What's the Commonwealth have to say?
Your Honor, we have a plea on 25 CR, and I don't know, Mr. Bell, did you turn the information in, or does this court have, the clerk have that?
I've got it right here.
Well, it needs to be turned in to sign a number, so I don't know if they got it or not. That's my question.
I don't think that case is a little off, so.
Shit, I don't like that.
Yeah, that has to be turned into the clerk so they can sign a number. The information does.
Is this a rocket docket? What is this?
Well, he was on, we've had a lot of these lately. We've had people on probation for possession and pick up another possession.
Yeah, I'm just asking.
So we've done the information so we could do
Yeah,
a
I'm just asking.
long-term
what it
treatment. No,
is,
I'm not
so
fussing. I'm just saying that's what's
I'm
happening.
not fussing either. I just want to know what.
But
it is.
evidently, defense counsel doesn't know to turn these in.
What's the next number?
I did.
Yeah.
Well, we take care of it. I'm just trying to find out what we're dealing with.
I'll take it.
Yeah.
Where is Larry Buttram at?
He's in jail.
He's incarcerated there.
Yeah. Have you gone over that stuff with him?
Yes, we got all seen.
Okay, this is a felony plea.
Yes, Your Honor.
Okay. Mr. Buttram, we have gone over 24 CR 0093, and I understand you got a copy of the information.
Yes, sir. Everything.
These new charges against you are going to proceed by information.
If I may, Judge, there was one he'd been indicted on, is my understanding, and then one that was in the
Well,
box.
somebody needs, let me, here, take this.
All right.
You know. Somebody needs to explain this to us here. Is this by information and you said there's additional indictment or what's the deal?
Well, there's an information and there's.
We'll see y'all next month on this case.
24 CR 93.
Well, I hope not, Judge. We got a place for him to go.
I got a place for him to go too, but I gotta know what we're dealing with here. I mean, I've got a probation revocation. They say there's information and you just told me that while Mr. Stockton walked with, there was another indictment. Is there another indictment?
No, there was one in the box, and that's one we're dealing with on the information.
What do you mean in the box?
Pending indictment.
You gotta explain all these terms to me. I'm not as familiar with the street or jail jargon as you are. I've been out of practice for a while, you know what?
Not that long.
Just 12 and a half years.
That ain't that long. You ain't forgot.
Depends on whether you're doing it or not, I guess. Whether you're
Yes, sir.
serving the time or can go in and out.
That's true. Judge.
So explain to me one more time. We got information. Now you have a copy of the information? I don't.
I do, Judge.
Yeah, I don't want the plea agreement. I want the information.
Yes, sir. And there that is. And then, do you want the order in lieu of revocation?
No, I just want the information. I've got a rating.
Yes, sir.
Okay. Mr. Bertram, you've previously been identified. The grand jury, the grand jury hadn't acted on this, but you're proceeding by information. And that you did commit the offense of possession of a controlled substance, first degree, first offense. Now, Mr. Bell, do you acknowledge the identity of your client, receive the information docket, waive formal reading and arraignment, and you're ready to enter a plea? Is that correct?
That's correct, Judge.
Okay, I'm going to give this to the clerk's office here. Now, sign the next CR number. 25 CR 50. 00050. Now, that Mr. Poland. I'll match it here. Okay, Mr. Bertram, a motion been said that you wish to enter a guilty plea under this new information. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Sir.
Is this plea freely, voluntarily given?
Yes.
Are you the same person that was just identified a few minutes ago in 25 CR 00093 and now 25 00050?
Yes, sir.
Okay. Is your judgment impaired today in any way?
No.
Have you discussed this charge with your attorney? Are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you, and do you believe that you're fully informed about your case?
Yes.
Understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speak, trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt your guilty charge against you. You understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation prior to accepting the recommendation. I'll wait a pre-sentence investigation report to be done by probation and parole. If I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea. What is the Commonwealth's recommendation?
Your Honor, Mr. Bertram will plead guilty to possession of a controlled substance, first degree, receive a sentence of 3 years,
probated for 5 years, supervised. This 3-year sentence shall run consecutively with Monroe indictment number 24 CR 93. He shall enter and complete a long-term treatment facility scheduled through probation parole. They'll provide transportation. He'll receive credit for time served. Once he's released, he'll obtain gainful employment or do 30 hours community service. He agrees to have all evidence in this case destroyed and pay court costs at discretion of the court.
Is that your understanding of the Commonwealth's recommendation, sir?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the information?
Yes, sir.
You're doing so of your own free will?
Yes, sir.
Knowing your constitutional rights have explained it to you, is it still your desire to proceed with the plea? Allow the court to fix your punishment in the range permitted by law. Is that correct?
Yes, sir.
Do you understand that after entering this plea, any future convictions could be enhanced as far as the range of penalties? And you have the original document. Could you hand it to me and I show the signature?
Yes, sir.
Is that your signature on there, sir?
Yes, sir.
Okay, I'll accept the plea, order pre-sentence investigation report to be done by probation parole.
Judge, is there any way we could
No.
waive? We've got a bed for him tomorrow.
No, I can't do that. I've got, what's the
I don't
comment?
mind him going to the healing place, but when we entered this agreement, we thought he was going to be assessed and find long-term treatment through probation and parole. So I contemplated he being released after sentence.
This is probation and parole uses the healing place often. Is
I've got no objection to him going there.
Right.
My intention was that he'd be released after sentence. We have trouble finding people sometimes and getting them sentenced when they go to rehab.
I'm going to send him after sentencing. Okay.
All right, Judge. Could I ask you one other thing before I leave?
You don't have to leave. You're welcome to stay.
I know, Judge, but I got court in Hart County and I'm gonna have to do that by Zoom, but I had Danny Sheffield on for today. And Danny had a medical condition. I believe I asked Mr. Hummel to come back and talk to him. He saw it himself. It was with his heart. We have an agreement and everything done. I would just ask the court to pass him to
It's an
that.
out of custody document, 25 CR 0030. What does the Commonwealth have to
I don't
say?
have any objection if the court's okay with it.
What do you want to do? Put it off to the next rule day?
Yes, sir.
October the 16th for Danny Sheffield is here or is it where?
He was, Judge. He had to leave due to his medical condition. He was having heart issues and diabetic issues. And I believe his legs. He was
Okay, all right. all
pretty
right.
pitiful.
Okay.
Thank you, Judge. You have a good day.
Yeah. Okay. Let's go back to the Barron County Detention Center, Kaylee Hill. Mr. Butterfield, your attorney will be over to talk to you about this. Kaylee Hill. Kaylee Hill.
I'm here, Your Honor.
Mr. Bell, you're on this one here, aren't you?
No, it's Mr. Garrett.
Yeah. But it's on the docket. Okay, where's Mr. Garrett?
He was on Zoom. He said he was gonna be on Zoom, so I don't know.
Kaylee Hill.
I'll send it here.
What?
I'll send it here.
Yeah, he's probably back there in one of those conference
He was
rooms.
sitting right there a minute ago.
Yeah.
Anybody see if they can find Mr. Garrett?
We're gonna pass around.
Move on to Timothy Jackson. Timothy Jackson. We'll come back to Kaylee Hill. We can't find your attorney right now. Commonwealth versus Timothy Jackson. 25 CR 0048 for arraignment, 25 CR 0031 for pretrial conference. You are Timothy Jackson.
Yes, sir.
You're born in 1984. Last four digits are.
Yes, sir.
Okay. You have right to remain silent. Your counsel is here. The grand jury of Monroe County has returned an indictment charging you with possession of a handgun by a convicted felon, being a persistent felony offender, possession of controlled substance, methamphetamine. Driving on suspended license, expired plates. No registration receipts. Failure to have insurance. Reckless driving. Disregarding stop sign, fleeing evading. Fleeing evading on foot. PFO 2 counts. As far as fleeing evading on foot and in the vehicle. No motor vehicle insurance. And speeding. Mr. Bailiff, will you present this to the counselor? You acknowledge the identity of your client, receipt indictment, waive formal reading and arraignment, and a plea of not guilty, reserving all pretrial motions.
I do, Your Honor.
What does the Commonwealth have to say?
Your Honor, I believe we have Mr. Jackson indicted on all of his cases now in Cumberland and Monroe County. So if you want to set a negotiation date on October 3rd, that'd be good.
October the 3rd here in Monroe County at 9 a.m. for negotiation date. And the next court date is October the 16th. And if it is necessary, we can, for judicial economy, we could transfer those cases over here for negotiation. So I'm signing a reciprocal discovery order, Jackson, that requires the Commonwealth to give you all information, prepare for your defense. Your attorney will be able to see it on that October 3rd date. They're going to take a look at your Cumberland and Monroe County things, see if we can wind them up together, okay, and see where you are. Thank you very much.
Your Honor, there is one other thing on Mr. Jackson. Mr. Jackson, a couple of months ago, his father had passed away while he was incarcerated. The court was at that time not willing to allow him a furlough. Well, unfortunately, Mr. Jackson's sister has also now passed. Her funeral is scheduled for tomorrow. I have spoken with the jailer, who has indicated that he would be willing to transport Mr. Jackson to and from the funeral and supervise him while he is there. I do have the funeral information with me currently if the
How's
court
the
is willing.
Commonwealth feel about that?
I don't have any problem as long as he's under suitable guard and chained. I don't want him escaping. You understand what I'm saying?
Yes, sir. Yes, sir.
Okay, well, I'll sign a furlough to allow him to go to his sister's funeral.
Thank you, Your Honor.
Okay.
Your Honor, do I need to submit an order to the court or should I just provide the information?
In an order.
Yes, Your Honor.
Thank you.
Yeah. Ethan Line. Commonwealth versus Ethan Line, 25 CR 0026 for sentencing. Are you Ethan Line?
I'm Ethan Lynn, sir.
Lynn? That's how you say your name, okay. Were you born in 19?
Yes, sir.
Last. You're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
You said,
You have?
Judge, you confused me when you said line, but if this is Mr. Ethan Lynn, we've gone over that, Judge.
I just corrected it
Yeah,
a few
I got
seconds ago. Have you had an opportunity to look at the pre-sentence investigation? Is it substantially correct?
Yes.
Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On a plea of guilty to possession of controlled substance first degree, the defendant shall receive 1 year to serve and all paraphernalia will be destroyed. What are the court costs in this case? Court costs are $240. You can start paying the court costs 30 days after you are released from jail, okay? Thank you.
Thank you.
Nathaniel Metter. Nathaniel Metter. Commonwealth versus Nathaniel Metter. 22 CR 0017. Are you Nathaniel Metter?
Yes, sir.
Were you born in 1997?
Yes, sir.
Last four digits. We're here on a probation revocation. What does the Commonwealth have to say on Mr. Metter?
Okay, Your Honor, it's a motion to revoke. It's theft by unlawful taking 5-year sentence. He got a new misdemeanor arrest, AI and drug paraphernalia. I'm willing to recommend the specialty court program if he's willing to take it.
Your Honor, this is Mr. Parent's case. We have not had the opportunity to talk to Mr. Metter, so I'm not certain whether or not he would agree to do drug court. If we could put him on for next month's docket.
October the 16th.
Thank you, Your Honor.
Okay, well,
To take it in the interim, they just need to contact me.
well, wait just a second. Mr. Metter, these public defenders are saying that they have not had an opportunity to talk to you. You caught these new charge, and what the Commonwealth is saying that they're willing not to revoke you and give you an opportunity to go to drug court, specialty court. So what they're going to do is come over and talk to you about that. If you do reach an agreement on that, I will go ahead and do that by agreed order. So you won't have to wait till the next court date. But I think it's only fair to allow your attorneys to explain to you the consequences of that and what's there. If you don't want to do that, then we'll have you back here on October the, what's the negotiation day?
October 3rd, Your Honor.
October the 3rd for negotiation. Well, the new charge is going to be felony charges or misdemeanor? Would you want him for negotiation or you just want him back here on
We can have him, let's have him on negotiation so we don't fall through the cracks.
October the 3rd for negotiation and October the 16th is your next court appearance if you don't agree to the specialty court by agreement. Okay?
Yeah.
Kevin Page.
He was gonna have a notice, we transported.
Kevin Page is here. We're gonna pass over Kevin Page. We'll pass over Ashley Pedigo, Tamara Stamper.
All right, a couple things while he moves on to other people. First off, we'd mentioned in the chat, where's Julia, where's Carissa, because we haven't seen them in a while. So I reached out to Julia. She just messaged me back. So it was nice to hear from me. Things have been good. They're really busy at work. They reorganized, so there's some micromanaging going on. So they're probably going to be gone for a while. But both her and Chris are doing well. And they said to say hi to everyone. So there you go. They've said hi. And also, Barbara mentioned in the chat a little while ago that she wants to support the show and the channel and help us grow. And thank you for that, Barbara. You've been that way since day one that you've been with us. The channel is doing well. We're adding about 2,000 subscribers a month. We continue to trend upwards, so that is great. This particular show, though, the live show, is one that definitely needs help and love, simply from an algorithmic standpoint. The algorithm, when it comes to live, will tend to pick what it thinks is the safe choice, for lack of a better way to put it. And it has not picked this channel as the quote-unquote safe choice for the morning show. So our biggest competitor gets about triple the viewers we do. The best way to help us out there, quite honestly, is to share it with everybody. If you have other social media, post links to the show there. If you have friends that are into court stuff, invite them to join. I know many of you have migrated over from other channels. If you know other people at the other channels, recommend us to them. That's the best way that you can help. This live show is kind of the long-term play for the channel, and it will need your continued support to grow. So, like it, be active in the chat, share it with people. All those things help. But enough of me droning on. Let's go back to Judge West in Texas.
So Ms. Tebow was previously here, entered pleas of true to counts 2 and 4 in the motion to revoke probation. And I've received the updated pre-sentence report. Have you all received that updated report? Any additions or corrections to that other than the one that I already made?
Nothing but
And there was no agreement. Is there any evidence with regard to the other counts, Mr. Hoffpower?
any new, meaning new failed to register.
No. I don't know. She pled true to counts 2 and 4, so there's
Correct.
obviously some other counts. Do you have any
Right.
witnesses or evidence
No,
with
no.
regard to those other counts?
We're gonna full abandon those counts, we'll just proceed on 2 and 4.
Okay.
Other than I call my probation officer, but, you know, I like her opinion.
Okay, so I guess there was an arrest in
It's in Florida.
Palatka, Florida. Okay. Hold on a second. Let me.
Putnam County, you know.
Okay, so count 1. Why don't you have any evidence with regard to count 1 if your probation officer's here?
Sure, we can call it, I'm sorry, apologize, Your Honor.
Ma'am, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may proceed.
Would please take the name from the record, please.
Sarah Simon.
I'm the son of our youth probation officer, assigned in this Peter.
I am.
Okay, and how long have you been first supervision officer?
Year and a half.
Okay, and throughout the time that you've been a probation officer, has you complied with the terms of her condition? In either one of the cases?
Speak up, please. I'm sorry.
Okay, no, she has not?
She's not.
Yeah, okay, in what instances has she not complied?
Steve-O has had consistent reporting habits. She was not paid towards her processed fees. She lived within the 2
Was she allowed, first of all, was she allowed through her probation here in Texas to venture out of the state and be in Florida?
She did not.
Okay, she wasn't allowed?
She was not allowed.
Is she allowed through her reporting as a sex offender to move or go to another state without no probation? Is she allowed to leave the state?
Not without.
She pled true to that.
Okay.
Count 1 is that she has not reported since January 27th of 2025.
Is that true, ma'am? That she,
That is true.
and intermittently, or she is fully, she's been called absconded?
She is absconded.
Okay, since that day?
Yes. Or 90 days after that time in January, she became absconded.
She been absconded. Okay, and since she reported since the time on which she was arrested?
She has not reported
Have you spoken to her at the jail?
at the hearing.
All right, did she give a reason for why she didn't report?
She did not.
At this time, I'll pass it on to you.
Okay, I also would like to know, Ms. Simon, were you able to confirm in any way the arrest? Obviously, she's gonna say she didn't do it, and that's okay, but if she was actually just, whether an arrest happened in Florida?
Yes, I did obtain an arrest report from Florida.
PC, okay. But do you have a problem cause, or you have a full offense?
The full
Okay, for what crime was she arrested?
There's 2. I think one was petite theft and then obstruction by disguise first.
Okay. Was it all the same incident?
Yes.
And what date did that occur, according to the law?
June 29th, 2025.
And were both those committed?
Objection as far as committed, Your Honor. I don't object to her listing evidence as far as an arrest. but
An
as far
arrest.
as the actual commission, it could violate a right to free cross.
Did the allegation occur?
Yeah, the arrest.
The arrest occurred while she was on probation?
Kelly, this just did something again.
Correct.
And those haven't been resolved in your knowledge?
Not to my knowledge.
May I proceed, Your Honor?
Yes.
She initially failed to report in January, is that right, of 2025?
That was the last face-to-face contact I had with
January 2025, then arrest, June 29th of 2025.
Yes.
So February, March, April, May, June, 5 failures to report. And she went into absconder status March of 2025,
Maybe April,
April,
like 90 days after.
90, so April 2025, she became an absconder. 2 months after that, she was arrested in Florida, is that right?
Right.
So you were aware if she was in Florida, which state, when were you made aware that she was in custody in
I
Florida?
received a phone call from somebody that let me know that she was arrested and in jail in Florida. And then that's when I received this arrest report.
So when did there was an MTRP entered into NCIC, I guess, after April? Was there an MTRP and that's why Florida advised you there was an active warrant for her then?
There was an active warrant for the interim. She was arrested for the.
Right, and that warrant popped up in Florida.
Correct.
So from June 29th to today, she's been in custody, is that right? So
I
she
didn't try
couldn't
to
have
open anything,
reported
it just started doing stuff
to
on its
probation
own.
department, she's in custody from June 29th to today because she's locked up. So that's not her fault that she didn't report because she's in custody, correct?
She was in custody.
So she can't.
Right.
As far as supervising her, she has reported, you say inconsistently, but that means she has reported some, correct?
Correct.
During the times that she has reported, have you been able to interact with her appropriately? She maintain proper demeanor, that type of thing?
She was, yes, but she was consistently late. I had to reschedule her several different times to get her to come to the office.
Have you had any other difficulties with her as far as just maybe perhaps being late or scheduling, as far as your actual interactions? Does she maintain appropriate demeanor, acted appropriately with you?
Yes.
Would you object to continuing to supervise her?
I would.
Why is that?
My personal opinion, I don't think it's too close. Sees her probation as a priority. She has been on probation, I think, since 2022 and has made no progress in regards to her fees. She did some community service, and that's about it.
When you say progress, how do you measure progress on probation?
Satisfying her court order conditions.
And how has she fallen short other than the reporting and fees and community service?
If she committed
So
any
is this correct in the, hold on a second, hold on. Is in the updated report, it states that since she was granted supervision, has reported 6 times for scheduled office visits. Is that a correct number? Okay. 6 times since 2022.
I have another question, Your Honor.
Let's let Mr. Kimler finish.
If she were to be extended, which the court has the power to do, I mean, you would continue to supervise her, right? Or would you have a problem with supervising her before she
I would work with her.
see any indication of need for some type of mental health referral or anything of that nature? I mean, I understand she's only reported 6 times, as the judge indicated. You see kind of programs or other things that probation could do for her to maybe perhaps to get her on the right track?
I think the only other option would be the cognitive change evaluation.
Pass witness.
Your Honor, is this the first time that we've been here on these 2 cases for a motion to revoke?
No.
Yeah, there was another time back in 2024 in which we had a hearing similar to this, not me, especially as the attorney, but she was brought in on a motion to revoke, and her probation was amended, and she was given 30 days in JCCL, and she was continued, and she was added to the mental health case.
The high medium risk case, and if she didn't report enough to be transferred over to the high medium risk case.
So this is not even the first time that we've been here on this, on similar allegations. That was a year in 2024, we did the same deal. Is that correct?
I might follow up on that. I believe in the previous HURP, she had a motion to revoke. She had federal charges, is that right?
Correct.
The NTRP was filed after she received the federal charges,
I believe so, yes.
and she was housed in the cell unit. Were you supervising her then?
No, it's not.
Do you know if the detainer was placed on her for that NTRP while she was in federal custody?
I did not.
Did she actually do federal time while she was on probation for this case?
That is why the NTRP was dismissed.
So she received, I think, about a year sentence in federal court for misprision of felony. Is that consistent with what she knows?
1 year of federal probation.
Prison, she was locked up, right?
She got probation.
She had 1 year federal probation.
Probation, okay, for misprision? Or you don't know? What the offense was?
I thought it was a possession.
Okay. Anyway, she received a year of federal probation, so she was not revoked and was allowed to serve the probation concurrently.
Correct.
So during the period that she was on federal probation for that year, do you know if she was reporting to a federal probation officer? Was any issues with the federal probation you're aware of?
According to Ms. Tebow, she successfully completed her federal probation.
And that was at the same time that she was on probation with Jefferson County, is that right?
Correct.
Was she reporting to you during that time period as well? What was her reporting record in Jefferson County during that period? I guess it was probably back in 2024.
Well, she's reported 6 whole times since, so obviously it wasn't great even when it was then.
But she was being supervised at least during that period federally, was able to successfully complete that probation, correct? Does that indicate to you that perhaps she could successfully complete Jefferson County probation? She's sufficiently
She
motivated?
has the ability to, but whether or not she has the motivation or the want to do so.
I'd pass one, Jim.
All right, any other questions?
No,
All right, thank you, Ms. Simon. Any other witnesses?
no.
I would defer to Ms. Tebow, Your Honor, if she wanted to address the court. I think she has written to the court, and that letter's incorporated in the PSI.
I received it and read it. Anything else?
No, I mean, when I did fail to report it, sometimes I was hard with scheduling, but a lot of it had to do with my mother being sick, and I brought my mother sick to her office with me multiple times because I wasn't able to just stay with where she was at. I brought her when I could. I mean, she's passed now, but at that time frame after.
But I mean, we're talking about since 2022.
I was in
Or
a
20
federal facility for a year and a day.
Okay. All right, so here's the thing. I'm not even sure where this agreement came from and why I accepted it in the first place, because giving somebody the minimum of 2 on a probation, so I have really nothing to do hardly on this. But Ms. Tebow, I mean, you've been given every opportunity over the last 4 or 5 years to do everything you're supposed to on this probation, and you've refused to do that. You flat out refused, and everybody, we all have different issues that go along with parents and family members and things that go wrong. And instead of, I mean, it looks like, I think one of the things that concerns me the most is that you called June 2nd asking why the police went to your home. June 2nd you called. And so your probation officer said there's a warrant because of your violations on June 2nd. Then you went to Florida and got arrested for 2 new offenses without registering, without obviously telling anybody where you are and the type of probation you're on, the offense that you're on probation for. That's probably the number one thing that you should do. So flee in the state when you know that there is a warrant for your arrest. Gives me no reason to leave you on probation. Unfortunately, I think for me and for the community, the most I can do is 2 years, and so that's what I'm going to do. I'm going to find, based on the evidence today, that counts 1 and 3 are true. So I'm going to find you entered your pleas of true to 2 and 4 freely and voluntarily. Find all 4 counts true. Find sufficient evidence to revoke your probation, and cause number 2239100, revoke your probation, sentence you to a term of 2 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 2239101, also find sufficient evidence to revoke your probation, and at this time revoke your probation, sentence you to 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. You need to sign that, please. I'm handing you the trial court certification that shows there was no agreement. You do have some rights to appeal. You can talk to Mr. Kimler about that, and he'll give you a copy of that as soon as y'all get it signed. Thank you for being here.
Okie dokie, friends, that brings an end to today. I hope you all had fun. I did. We got to see some good court. We got to see the birds that we rescued move on with their lives, so that was cool. And all in all, not a bad morning at all. We'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. After a 1-week hiatus, we're back there. We're going to be talking about body cameras. Are they helpful? Do they hurt? Is it good for transparency? Do they create more problems than they're worth? We'll just debate the whole thing and see where it goes. So join us then, 8 p.m. Eastern, 5 p.m. Pacific. And then we'll be back here tomorrow for the morning show, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. Go have yourselves a good Tuesday. Make it the best day that you can. Take care. God bless.